Thank you. This appeal hearing is in the matter of case number CA016-2022 before Chief Justice Zaki Azmi, His Excellency Deputy Chief Justice Madhani, Justice Lord Angus Glennie. The appellant is represented by MRP Advisory FZ LLC. Lead counsel is Mr. Alexander Burrell. The respondent is represented by Tamimi and Company. Lead counsel is Mr. Justin Mort KC.
Yes, Mr. Alexander Burrell. How do you? I don't like to mispronounce a person's name. So Burrell.
Yes, my lord. Burrell is fine. Thank you, my lord.
Burrell. Okay, Mr. Burrell. How are we going to start this?
So I think the first issue is just a matter of housekeeping in terms of the timings for today. Now, I understand my solicitor's MRP emailed the registry yesterday to confirm that the sitting times, and having discussed with my learned friend, Mr. Mort, we've agreed a loose timetable for today and tomorrow. We've got the email from the registry that I think was sent in relation to the break time for today. As far as the appellant is concerned, that is absolutely fine. There's no issue with the break being at 3:30 to accommodate. The only query is whether the court is prepared today to sit until 5:15 Dubai time, and or slightly more or less, depending on how we get on with the submissions, so that hopefully we can get through the contractor's appeal today, and then there'll be a shorter day tomorrow to deal with the employer's appeal, because we need to deal with the application as well at the start of today.
Shahla, any objection from you sitting up to say 5:30 Dubai?
Not at all.
Not at all. Fantastic. Judge Ali?
That's good with me.
I asked the registry first.
No, you're the one. You're the one who's going to stay very late. You're in Malaysian time. You're going to go to 9 o'clock.
9:30 Malaysian time is quite okay with me, because I don't go to bed until 10:30. So 10:30, 11 o'clock. So it's not a problem. Yeah, Angus, you should be happy with that. No problem for you. Mr. Burrell and Mr. Mott, are you in England? UK time?
I am, yes, my lord.
Good.
I'm also in London, thank you, my lord.
Good, fantastic.
Can I just say, I haven't seen the change that my learned friend just referred to. So I'm working on the timetable that I drafted, but my learned friend indicated there'd been some adjustment to the break. I'm afraid I've no idea what that is.
Yes, I requested a break at 7:30 Malaysian time, which is, I believe, 11:30 UK. 2.5 hours from now. 2.5 hours. Yeah, 11:30 UK. The reason is I have to do my evening prayers, and that is, the window is 7:30 to 8:30 or 8:40. That's about all I have. And at the same time, I just also realized that Justice Ali has to do his afternoon prayers, which is 4:30 to whatever it is. So he's quite happy to take a break about the same time. And Mr. Justice Lord Glennie has no objection with our proposal. And now it's just, I hope the parties have no objection to that as well.
So I think the only point to clarify is whether we still want to have a break at the earlier time. I suspect we don't, and then we just that break at 11:30 is the first break and the only break today.
But
that's fine for us.
If in between that you need to take a 10-minute toilet break or something, don't hesitate to just let me know, and then we take a 5-10 minutes short break. Last week I had typists, and the typist said, no, we cannot do for 2.5 hours continuously. They wanted the break in between, which we decided to have a 10-minute break, another 20 minutes later on it. So 2 breaks instead of 1 break. But if you agree and the judges have no objection as well, then we can have 1 half-an-hour break from 7:30 Malaysian time, 7:30 is 3:30 Dubai time, and 11:30 UK time.
I'm grateful, my lord. That's fine for the appellant, and I just want to say thank you very much to the court and to the registry for sitting later today. Very grateful.
It's not all every day they do that, so it's okay. Okay, so now that's the housekeeping part of it. Now you want to go on. We will hear. We have had some discussion before the hearing, but we have decided to allow you to start off with your submission, and we'll interject and we'll put our concerns as you go along.
Grateful,
And I suspect my learned brother, Lord Glenn, will be quite acting actively at this hearing. He's very, very familiar with the provisions of the contract that you'll be citing. Must confess, I'm not that familiar, but I think Judge Ali also is quite familiar with the provisions of the FIDIC contract and things like that. So we'll just hear what you have to say.
Grateful, my lord. I think the first matter is the contractor's application. So there's two parts to that. There's the permission to rely upon the additional skeleton that was filed 2 weeks ago, and permission to rely upon the new point. Has the court had the opportunity to read my further supplementary skeleton that was filed 2 weeks ago?
Yes. I have. The judges have no objection to giving that time, unless, of course, Mr. Mott is very, very strongly against that request. Mr. Mott, would you have any objection to the request to consider the additional submissions?
My lord, thank you. We're very grateful for the additional submissions. We have no objection at all to my learned friend relying on the additional cases and additional commentaries that he refers to. However, it's a different matter where he appears to be seeking quite different relief and applying to make a change to the grounds of appeal and the remedy sought. So in terms of what he addresses in his supplementary skeleton argument, that it seems to us to be only helpful to the court to, if necessary for the purpose of my learned friend's submissions, to look into the older cases, although we obviously say they're irrelevant, but we have no objection to my learned friend taking the court to them. As I say, nor do we object to the court considering learned commentaries by Tony Marshall or Doug Jones, but as I say, we do object to any what appears to be a significant change in the relief being sought and the new argument that, for example, the liquidated damages are disproportionate and grossly disproportionate to the loss suffered and so on. I should just point out I mean, obviously, my learned friend was involved in the trial, which took place in September 2021, so some 18 months ago, and obviously dealt with the closing submissions, which continued towards the last quarter of 2021. In addition, of course, my learned friend then prepared the grounds of appeal and 2 sets of skeleton arguments. In contrast, I was instructed for the purpose of the appeal only, and Mr. Dylan Malone of counsel has left Altamine, is not available to assist on the appeal. So in those circumstances, as I say, whilst I'm entirely happy to deal with, as it were, purely legal argument and citation of authority, that seems to be totally reasonable and acceptable. It's a different matter when my learned friend starts to contend, for example, that the calculation of damages is disproportionate to the loss suffered, which potentially gives rise to factual matters and as it broadens the inquiry considerably. So in short, my lord, we accept it in part, but subject to that exception.
Yeah, Mr. Borrell, why can you justify why you want to come up with new grounds at this stage?
So this relates to the second part of the contractor's application. I'm grateful to my learned friend, Mr. Mort, in relation to the indication on the first part. So the second part of the contractor's application is to apply for a formal permission to amend its appeal notice. So if I take the court to I9, and I can direct the court there, I think on the case lines, I think that, and so if you if you scroll down to the very bottom there, and if you're looking at paragraph 35, 36, 37, and 38.
Yes, before we proceed, I would like to request we all use these case lines where you direct us to the page, to the relevant page, as you have done now, Mr. Burrell, so that we can, I just press yes, and then we go straight to the, without we having to punch in the page number and things like that. So you want to go to I-19, or is it 19? Or is it
I-9.
I-9. Okay, I got to I-9. I-9, yes, I-9. Yes.
Grateful. So the second part of the contractor's application is for permission to amend its appeal notice. The point that the appellant makes is that, in fact, the point that we're seeking to rely upon is only a supplemental part to ground 6. But in any event, if it is considered a new point, as my learned friend contends, that we request permission to amend the appeal notice contained therein. So the argument is summarized in my skeleton at paragraph 37, namely that it was found by the judge in respect of delay that the contractor's non-compliance in this case was 19 out of 325 days. But the judge still awarded full liquidated damages in the sum of 4.18 million dirhams because of the contractor's alleged failure to comply with notification requirements. As such, the contractor contends this is grossly disproportionate to the loss the employer suffered as a result of the delay. Liquidated damages for 19 days would only come to 807,000 dirhams or thereabouts. As such, the point is the court's requested pursuant to Article 1222 of the DIFC contract law to reduce the liquidated damages. Now, the reason for the timing of this application is because this point arose during the further development of the contractor's arguments as it prepared for the hearing. The contractor suggests it's a side argument to its ground 6, but it arose, as the case was continuing to be prepared, and as such, permission was sought. Now, I've got 5 submissions as to why permission should be granted to allow the amendment of the appeal notice.
At what stage was this application made again? At what stage of
2 weeks ago? 2 weeks ago.
It's a bit.
I appreciate it. I appreciate it's a short time before the hearing, but I'll deal with that. And my first submission is to deal with that, which is that it's a very narrow point. It's a very narrow request, and it's a very narrow legal issue to deal with. And as such, it's submitted that within this appeal hearing,
can you put this under one of your other submissions as a submission?
Well, indeed,
instead of taking a separate point altogether.
Indeed, it is my submission that to a certain extent, this is a side or supplementary point to our ground 6. That is my main submission, and indeed there isn't.
So why do you want to seek an amendment? It just put under that particular ground.
It's out of an abundance of caution, my lord, because as my learned friend contends, he suggests that this is indeed a new and completely separate point. And so out of an abundance of caution, we submit that, or we request that to the extent it is considered to be a new point, that permission to amend the appeal notice is granted. And so my second submission is that whilst it was only raised 2 weeks ago, in my submission, the employer is not prejudiced in having to respond to this because it has had 2 weeks to look at it. It is a narrow legal point in relation to the exercise of discretion under Article 122. And indeed, it is at most, in my submission, a supplementary or a side point to our ground 6. Third, conversely, the contractor would be prejudiced if the court considered that this was that permission was needed to amend and permission was not granted, as it's possible the contractor would then be deprived from reliance upon this legal point and possibly made to pay grossly excessive liquidated damages. My fourth submission is that To the extent that this is considered to be a new point, it's submitted that this is a pure point of law, which does not require any further factual investigation. And as such, pursuant to this court's judgment in Damac Park Towers, at paragraph 66, there's no reason to preclude admission. So in short, where it's a purely legal point, there's no reason to preclude admission of it at a later stage. So in my submission, this point only concerns the court's discretion to adjust liquidated damages from the maximum to the pre-agreed loss for the period of time which the contractor actually caused delay. The parties agreed liquidated damages as the remedy for delay and as a genuine pre-estimate of the employer's loss, with a daily rate applicable for each day of contractor caused delay. No factual evidence is relevant to that point. The contractor's argument relates solely to the adjustment of liquidated damages, i.e., should liquidated damages remain at the maximum amount, which would compensate for 98 days of delay or more, according to the daily rate, or should they be adjusted to the period for which the contractor actually caused delay, which has already been finally determined by the first instance judge. As such, there's no evidence, there's no factual evidence that we'd be affected by this argument. It's a legal argument, and as such, there's no reason why the court shouldn't entertain it today. As stated, whilst it was only raised 2 weeks ago, and indeed criticism can be made of that, it does not prejudice the employer from having to deal with it because it is such a narrow point. Finally, it is in the interest of the development of DIFC construction law that the contractor is permitted to fully ventilate this point. It's important for the court to be able to consider all relevant legal arguments and be able to give a ratio decidendi, which will enable the parties to understand how this provision of DIFC contract law might affect the determination of liquidated damages when there's been non-compliance with notification conditions precedent, if indeed that is the finding that's later upheld. So those are my submissions on the amendment to the appeal.
Thank you, Mr. Mott.
Thank you, my lord. Obviously, it's important that issues are decided on their merits and the parties have full opportunity to deploy whatever arguments are appropriate. It's not quite as simple as my learned friend suggests. It was raised 2 weeks ago. The following day, I had to leave the UK to go to Qatar to deal with other matters, and I had allowed sufficient time to prepare for the case, which obviously I already knew. I had not allowed for a lot of time for an additional significant point. Now, my learned friend says, well, it doesn't require any new evidence. The key characteristic of my learned friend's supplementary submission is to pray in aid in some detail the concept of good faith. Now, I accept that good faith was mentioned in passing in the original skeleton argument, but it isn't explored in any detail whatsoever. No authorities referred to, no explanation. It's simply a passing reference to what my learned friend suggests is a sort of general understanding of what good faith means, totally undeveloped. And we responded in similarly light terms to say this isn't really relevant. It's very different how my learned friend puts it in the supplementary skeleton argument. Now, we are going to have to look at the very limited reference to good faith in the DIFC law, but it's rather different how when my lord looks at my learned friend's supplementary skeleton, although short, it does mention quite a lot about good faith. Now, that triggered us to scurry around as quickly as we could to see, well, what authorities can we put forward on good faith and what that means. But that's quite a big topic to suddenly raise, so far as I was concerned, because of my other commitments, just a few days before this appeal starts.
Mr. Mott, what if the court gives you another 2 weeks to come back in written form to reply to what Mr. Burrell is going to raise, and you come back to us in a written form 2 weeks from tomorrow. So that gives you another 2 weeks to reply. We'll hold our decision until we read your reply.
My lord, of course, we would much rather a proper determination of the issues. I mean, we will be very grateful for that opportunity. Obviously, that's going to increase the cost. There's going to be some cost consequences to that.
They're going to pay the cost, not you. You're going to benefit from that.
that obviously that makes it a much more attractive proposition, my lord. Secondly, I do have quite a busy 2 weeks. If we were having this conversation a month ago, it'd have been a bit different. But subject to the fine tuning, my lord. Well, of course, we would be very grateful for that additional opportunity, and I acknowledge that would take away a lot of the force of the points I've been making.
Speaking for myself, my practice has always been to allow parties, not so much counsel, but parties, your clients, to be happy that their case is properly ventilated and the court is given the opportunity to hear what they want to say. That is what I mean. That's my personal practice. I don't know what Justice Lord Glennie or Justice Ali has to say about this. Maybe the practice in the Supreme Court of England is different. I do not know. Maybe you can assist, Angus.
My approach has been broadly the same, to allow parties to develop their arguments, even if it involves a departure from the way it's been previously put, with this qualification that we've now reached a stage where all the evidence has been heard and arguments have been, cross-examination has taken place on a certain basis. So if at the end of the argument it turns out that we consider it wouldn't be fair to allow the point to determine the outcome, then the court should have that power simply to say, well, this is a very interesting point, but having heard the argument, we think it would be prejudicial to decide on this basis.
But as long as it involves facts, but if it doesn't involve facts, we accept the facts as it is and we just decide on the law. We give an opportunity to, this is very unusual for judges to discuss right in your presence. Nevertheless, so let's see what Judge Ali has to say. Muted. You're muted.
I do agree with the concept.
Yeah. So I don't know. If Lord Glennie, you want to say something?
I was going to say I think we should hear the arguments. I'm happy to go along with your suggestion of allowing 2 weeks for further written submission on the point by Mr. Mort. Although I wouldn't want it to become an open-ended exchange of written submissions.
No. I mean, Mr. Burrell, you delayed. You want to submit. We will allow you to submit, and Mr. Mort to counter, make a reply to that. And I think that's it. We are not going to hear your further reply. So whatever you want to say, you say now, and that's your last. Then we'll hear Mr. Mort. We'll give Mr. Mort 2 weeks to put in the written submission, and that's it. And then we'll make our decision.
I'm very grateful, my lord. I think that I've already made the point. I'll come on to these submissions in relation to that ground. Well, I can make them now if that's preferred, but I was going to deal with it a bit later when I
raise it at the time when the particular topic is relevant.
I'm very grateful, but just before I move off it and start the appeal first, the one point I just wish to raise.
Wait. Before that,
and it's in relation to
before that, Mr. Burrell, Registrar Shala, please take note of the order. We allow the application by Mr. Burrell, subject to the court giving an opportunity to Mr. Mort to put in a written reply 2 weeks after tomorrow. 2 weeks is what? Can you give a date?
My lord, can I ask for the 17th of March? Can I ask for the 17th, which is for 2 weeks on Friday? I know I have a substantial hearing in 2 weeks' time, which is going to involve quite a lot of preparation. So if we said the 17th, would that be acceptable?
By the 17th, okay, that's fine. I prefer the 4 p.m. on the 17th. Mr. Mort will put in his reply 4 p.m. on 17th.
And then
that is the order of the court.
Will be placed before the bench for determination. Yes.
Yes. Okay.
Yes, Your Honor.
Yes, Mr. Burrell.
Yes, my lord. So thank you. I'm very grateful to my lord for his indication and indeed the opportunity for Mr. Mort to respond. The only point I wanted to clarify arises from Mr. Mort's submissions. Mr. Mort made submissions about good faith and suggested that the issues of good faith were an entirely new submission, which was why authorities, which is why for the first time the respondent put forward authorities on good faith and has had to deal with the issue of good faith. Now that's not entirely accurate. The issue of good faith was raised very specifically within the appellant's initial grounds. If I just take you to D30, which is on the, I've just directed everyone to.
Have you?
Yes.
This is ground 6, and this was the contractor's initial ground, and indeed its reliance upon Article 57 CD, paragraph 94. You can see it's all about the incorporation of good faith, and this was an argument made during the first instance proceedings. So in as far as good faith and the concept of good faith is concerned, that is not new at all. The only aspect of this case, which of the contractor's application, which could possibly be considered as new, is the reference to Article 1222 of the DIFC contract law. So that's at, I'll just take the court there now, it's E614, which is, so this is the DIFC contract law, which I'll come to later.
Mr. Burrell, could you just help me? For some reason, your direction is not coming up on my screen.
My apologies. I mean, is this, has that come across?
No. Have I got something off that should direct others to page? No.
Yes, I've just clicked that, direct others to page. Is that not coming through?
No.
Let me try again. I just tried again. Is that still not coming through for anyone?
No, not for me anyway. I don't know about.
I've got it. I've got the page on my screen.
Is your my lord? Is your page directions turned on at the top? I'm not sure if that's the function.
Yes, it is.
Notes.
Yes,
Press notes. Press notes. On the top.
Yeah.
There is
Okay.
this.
Notes and then find page. No.
Find page. Notes. Find page.
No.
Oh, your screen doesn't come up. That part didn't appear at all.
Well, notes does and find page does, but nothing from Mr. Burrell.
Oh, I see. Then type in E615.
Yes, I can do it. I'll do it manually myself.
Okay.
If
It's E614, my lord.
614. Yeah.
Yeah.
It's a short point, but the point that I was making was that in as far as there are suggestions that this new point concerns good faith, the contractor would refute that. Good faith was raised during the proceedings and during the appeal grounds, and submissions were made in relation to that. Whilst there were additional submissions, so once there is an additional submission and what could be considered a new submission, or is considered a new submission by my learned friend in relation to this point, this is a much more narrow point in the opinion of the contractor, and it just relates to the court's discretion under Article 1222 to reduce liquidated damages where it's considered that the harm resulting from that would be excessive. It's a narrow point, and that's the only point I would suggest that Mr. Mort should be entitled to respond to within his responsive submissions. Otherwise, I'll deal with my submissions on that point at a later stage when I get to that during the hearing. Okay, I'm grateful. Okay, I'll start making my submissions now in relation to the appeal grounds themselves. For the ease of reference during these proceedings, I'll be referring to the appellant, MESC, as the contractor and the respondent, PANTHER, as the employer. All of the contractor's grounds relate to the same issue, namely that in the judgment, the judge found that the employer was responsible for 306 out of 325 days of delay. That's 94% of the delay in this case. Yet, because the judge found that the contractor had failed to submit notices within the required period, both notices under clause 20.1 and notices under clause 3.5, and possibly also claims under 20.1, the contractor was not entitled to EOT. As a result, and usually instead of the employer being liable to the contractor for causing 94% of the delay, the contractor is liable to the employer for the entire 100% of liquidated damages, around 4.2 million, and is not entitled to claim its own prolongation costs caused by the delay, which the judge assessed at 1.7 million. As such, there's about 6 million in dispute for these grounds. Grounds 1, 2, and 4 all relate to the contractual mechanism for claiming EOT and whether the contractor is entitled under the terms of the contract to be awarded EOT. Grounds 5, 6, and now 8, which would be the new point we've just referred to, all relate to legal remedies, which the contractor relies upon to request that the court prevent the employer from benefiting from its own breaches. I'm not going to address grounds 3 or 7 as they are not necessary to address given permission was granted on the other grounds. So ground 1, and now this ground concerns the judge's interpretation of clause 20.1, that it is a condition precedent to EOT and additional payment, that not only does a contractor file a notice within 28 days, but they must also file a fully detailed claim within 42 days. So I'm going to take the court to D9. This is the contractor's initial appeal skeleton, and within paragraph 31, you can see clause 20.1 highlighted there with certain passages emphasized. The contractor has already set out detailed submissions within this skeleton, which are at paragraph 622 to 61. These submissions are already very detailed in nature, and I wasn't intending to go through them in the same detail today, unless the court wishes me to address them on any specific points. But I will address each of them briefly. I highlighted 5 submissions as to why the judge's reasoning regarding his interpretation of the 42-day requirement as a condition precedent was wrong within the skeleton, and I'm going to add a further one today. So I've got 6 submissions. So firstly, on a textual analysis, clause 20.1 clearly only provides for one condition precedent, the 28-day requirement. The relevant law on interpretation is set out within the skeleton. I don't propose to repeat it. It's relatively well-established law. On a textual analysis, reviewing the clause itself clearly indicates there's only one condition precedent, namely the requirement to provide notice in final paragraph of this clause. And if you scroll down to the next page, D10, and just above paragraph 32, you can see the final paragraph there, which states in the bold, if the contractor fails to comply with this or any other requirement of this subclause in relation to the claim, and in particular, that would be that would include the 42-day requirement, any extension of time or additional payment shall take into account the extent, if any, to which the failure has prevented or prejudiced investigation of the claim, unless the claim is excluded under the second paragraph of this subclause. And scrolling up, the second paragraph of this subclause says, if the contractor fails to give notice within 28 days, the time for completion shall not be extended. This final paragraph indicates there's only one automatic exclusion: failure to comply with the second paragraph, i.e. failure to provide notice in 28 days. There's no other automatic exclusions. And so on a textual analysis, the 42-day requirement is not a condition precedent. Second submission is that there's no clear wording that the 42-day requirement is a condition precedent. And this relies upon the law in Tullow, Uganda. So this is set out at D8 of the skeleton, which I've just directed everyone to. So at paragraph 28 there's an extract again with bold emphasizing for certain words. And it says here in particular, the final line, the words conditions precedent are often used, but it is clear that other words can have the same effect, as long as the clause is apt to make that effect the clear intention of the parties. So it must be clear that a clause is intended to be a condition precedent, and clear words must be used. It is not clearly expressed that the 42-day requirement is a condition precedent. There's no mandated consequence for failure to comply. It's only a matter to be taken into consideration, as compared to, for example, the 28-day requirement. My third submission is having regard to a contextual analysis of clause 20.1 and business common sense. It cannot have been intended that the 42-day requirement be a condition precedent. Clause 20.1 is not amended. It's a standard term of FIDIC 1999, widely used general terms around the world. It cannot have been the intention of these standard terms, or the parties in this case, that it is a condition precedent to EOT for parties to submit a claim within 42 days for each event. As set out within the skeleton, this would have a significant effect. Parties would prepare claims for every possible event, and it would encourage very litigious behaviour. It's not conducive for a positive construction environment, and it would impede progress on construction as resources would be devoted to preparing claims. Relatedly, it would also increase costs as contractors would have to employ more contract managers or claims consultants dedicated to these EOT claims. As such, if this provision was upheld as a condition precedent to EOT, in my submission, it's likely that parties would be less likely to use DIFC governing law, as costs would be much more significant in construction projects. My fourth submission, it's a brief one. During the trial, the employer never actually argued that the 42-day requirement was a condition precedent, something that the judge had decided on his own volition. And fifth, the judge has misinterpreted or misapplied education for Ayrshire. Now, I understand this is a case which, my Lord Glennie, you were involved in. Justice Field relies upon education for Ayrshire in his finding that a clause can be a condition precedent, even if it is not worded explicitly to be. However, this is wrong. The clause in education for Ayrshire was expressed in mandatory language, whereby if it was not complied with, there would be no EOT. The 42-day requirement is not in mandatory language at all, and so it's not similar. Sixth, the conditions precedent to EOT, and so this is a new or additional submission. Conditions precedent to EOT are required as a matter of law or common law to be construed in favour of a contractor. As such, where there are two different interpretations, the contractor's interpretation is required to be preferred. Now, I'll come on to this point in a bit more detail in respect of ground 4 later on. Finally, on ground 1, the employer's position on this ground is primarily to state that this would have no consequences if this ground was allowed, because the judgment didn't find that any claims were barred by this ground. Firstly, this is incorrect. If I go to B66, which is the judgment, and at paragraph 55, so it's above 56 there, it's the top paragraph. And at the very final sentence of that top paragraph, it says, it follows that MESC were in breach of the requirement imposed by subclause 20.1 to submit a fully detailed claim within the prescribed 42 days. So in relation to delay event 5, there is a finding that this was a failure, whilst it is an alternative if the contractor is successful on ground 4 in particular, this ground may come into activation. Second, and in any event, it's necessary to deal with this issue, as if the contractor succeeds on the other grounds, the employer could state that it failed to comply with this requirement. So it's necessary to deal with this point. Unless the court has any questions, I'm going to move on to ground 2.
Well, I just want to if I can, at one point this court will have to reach decisions on each of the individual points, so it's worth mentioning at this stage. If, for example, the court was with you on this point, where does the court find in monetary terms or in practical terms what it does?
I think for this point individually, if ground 2 and ground 4 were refused, this point individually wouldn't make a difference in monetary terms. This is the only one though. In respect of ground 2 and ground 4, there would be a difference if the court were to find if the court were to reject the other two, if that makes sense. But to a certain extent, all three, ground 1, 2, and 4, have a level of interconnection in that the contractor would only be entitled to full EOT and therefore, or EOT to 306 days, thereby reducing the liquidated damages if it succeeded on all three. But even if it succeeded on, say, ground 2, but not ground 4, there would likely be some possible difference in relation to prolongation costs, because there had previously been findings about submitting notice in time for some of the delay events. So there is a slight difference depending on the grounds, but certainly the biggest effect would be if all three are together. And if there is a difference, then there needs to be a slight further inquiry. I'm going to deal with that point a little bit more later on, my lord.
But at some stage, certainly from my point of view, I don't know about the other members of the court, when we've reached a decision on the various points of law, we'll have to work out what to do. And it seems to me a sort of flowchart, not argument, but simply agreed consequence flowchart would be useful.
I'm grateful, my lord. I do have submissions later on in relation to the provision of notice, which I was going to go through. But when we get to that point, if the court wishes that this to be dealt with in written format or otherwise, that can be done. But I'll make submissions in relation to some of that after ground 4. But yes, I'm grateful. Submissions can certainly be made on that if that is necessary. Are there any other queries in relation to ground 2? So ground 1 even.
Ground 1, I think, yes.
Not from me, thank you.
Not from me.
Great, grateful. Okay, well in that case, I'll make submissions on ground 2. Ground 2 concerns the judge's decision that pursuant to clause 3.5, a failure to challenge an engineer's determination within 14 days precludes the contractor from challenging that determination after this period. So if I go to D18, this is, again, the contractor's first appeal skeleton. So clause 3.5 is set out at the top there. And clause 3.5 provides that, and I think in particular, we're looking at the second paragraph. The engineer shall give notice to each party of the determination. Each party shall give effect to this agreement unless one notifies the other of his dissatisfaction within 14 days. Either party may then refer the dispute to be settled in accordance with clause 20, and clause 20 provides for referral to this court, the DIFC court. Now, on the basis that the judge had found that there had been a failure to comply with this provision, he found that the claimant was restricted in being able to bring a claim in relation to EOT that were the subject of those determinations and additional payment. Now, the contractor alleges that this is contrary to Article 123 of the DIFC contract law, which prohibits agreements to reduce the time limit to under 1 year. Now, the employer makes 2 submissions in response to this point within their skeletons. The first employer submission, and I think it's their main submission, is that clause 3.5 is not an agreement to reduce the statutory time limit. The statutory period remains the same under clause 3.5 with the same effect. In my submission, the employer's argument fails to consider the purpose of Article 1231, and I set out 9 submissions in this regard. The first of those submissions is, well, what constitutes an agreement contrary Article 123. So let's go, if the court could scroll down to page D19, and in particular paragraph 68. This sets out Article 1231 there, and in particular it's the final sentence. By original agreement, the parties may reduce the period of limitation to not less than 1 year, but may not extend it. So reduce the period of limitation. As such, the question for this court is what constitutes an agreement to reduce limitation to less than 1 year? Is this solely restricted to clauses which expressly state you must bring a claim within less than 1 year, or words to that effect? Or is it broader? And does it also include clauses which have the same limiting effect and consequently undermine the purpose of this legislation? As such, this is a policy decision for this court.
Can I interrupt? I'm terribly sorry.
Yes.
The thing that was puzzling me when I was reading this was this: if your argument is right, that the provisions of 3.5 are antithetical to Article 1231 of the IFC law, why would not the same argument apply to the notice provision in the second paragraph, 20.1?
Yes. Well, this was going to be my ninth submission, but I'll address it now. This is a point that the employer makes within their skeleton, and it's an interesting point to make. But there is a difference. So the employer makes the comparison that this argument isn't made in relation to clause 20.1. Now, these two clauses are in fact distinguishable. In respect of clause 3.5, the right to bring a claim has already accrued. The clause then bars the ability to bring that right to court unless steps are taken within 2 weeks. As such, it's an agreement to reduce limitation. So an agreement to reduce the period of limitation. So the right's accrued, but then you're not allowed to bring it to court because you've not done something. Whereas in respect of the EOT notification provisions within clause 20.1, this is a condition precedent to a right. So this clause provides that there is no right to EOT or additional payment unless these clauses are complied with. So the right has not accrued because of the failure to comply. As such, you don't have the right in the first place, and so you're not being limited from pursuing it. That's different to this clause, where the right has accrued, but you're then not allowed to bring a claim in relation to that right, because that's what clause 3.5 provides. So that's the distinction.
I see. So it's a matter of wording, is it?
Perhaps so, yes, indeed. Indeed, it is a matter of wording. If it's a condition precedent to the accrual of a right, then that's fine. But if the right is accrued, but it's then not allowed to be pursued because it's a limitation on agreement, or it's a limitation on bringing it to the court, then that's not.
It's a very narrow basis on to.
Well, indeed, it is my understanding that this is in fact the basis on which UAE onshore law deals with this issue, albeit I don't have any authorities on that, but that is my understanding.
All right. Thank you.
It's an accrual of a right, which is then you're not allowed to go to court with, would be a restriction on being able to bring it to court. Whereas if you don't have that right in the first place, then there's no restriction on bringing that claim. So it's not an agreement to reduce the limitation period.
Thank you.
So the first submission I had was effectively it's a policy decision for the court. And so the second point I have is, well, what is the purpose of the legislation in restricting agreements to reduce a limitation period to less than 1 year? It's firstly noted that there is specific inclusion for this prohibition under DIFC law. There's no similar prohibition under, for example, English law. As such, in the formulation of DIFC law, there was specific intent to legislate that it was not possible to agree to reduce the limitation to less than 1 year. This provision was specifically considered to differentiate DIFC law, therefore, from other jurisdictions. And indeed, it's perhaps closer to onshore UAE law, which there is a similar prohibition. Now, the purpose of preserving this 1 year period, it is submitted, is to enable parties to have time to consider whether they wish to bring a claim or not, which may involve extensive consideration of the evidence and require legal advice, which may take weeks or months to come together. It also allows parties to consider whether they should have whether to bring a claim or not, or to negotiate a compromise. The right to bring a claim to the court is a sacred right, and the court should be concerned as to contracts which restrict a party's access to justice in this regard. This provision within the DIFC contract law clearly is there to provide protection for parties, in particular in one-sided agreements, which is the case in many construction contracts. And it's to enable parties, in particular weaker parties, to consider their position for at least a year before deciding if it needs to take steps in respect of that right. So my third submission is a clause which requires specific steps to be taken in less than a year, otherwise a party cannot bring a claim, is an agreement to reduce the limitation period, as it undermines the purpose of the legislation. It does not grant the parties that legislated required period for considering whether to bring their claim or not. It requires a party to take positive steps, otherwise they lose their right to consider through that year. Now, my fourth submission is, as this contract is not on standard terms, there is no provision under DIFC law which allows the court to void or disapply contractual provisions because they're unfair, save perhaps for good faith. As such, if the court follows the employer's argument and refuses this appeal ground, and finding that Article 123 only restricts narrow agreements which expressly reduce the limitation period for bringing a claim, as opposed to the broader interpretation which the contractor contends, this opens the door to any number of onerous clauses which would circumvent the intention of Article 123 in non-standard term contracts. E.g., it could be agreed that a party must submit a fully particularized particulars of claim to the other party within 1 day of the right accruing. Otherwise, it cannot bring a claim for such rights. That's an example, that's an extreme example. It surely cannot have been the intention of Article 123 to allow parties to conclude agreements which would circumvent the intention of this provision, which is to allow parties 1 year to make a decision about bringing a claim. Fifth, it may be alleged by the employer that this is a matter of party autonomy. Parties should be free to contract as they choose. If they choose to have such restrictive procedures, that is their discretion. Except the parties aren't free to choose under DIFC law. Parties are not allowed to agree to limitation periods of less than 12 months. So there's no party autonomy in relation of that specific point. And I submit any agreement which has the effect of reducing the limitation period is therefore also void, and parties do not have autonomy on such agreements, as well as they undermine the purpose of the legislation. And my sixth submission is in respect of reasonableness. It may be alleged by the employer that it was not an onerous requirement for the contractor to have filed a simple notice of dissatisfaction within 2 weeks of the engineer's decision. But such a submission would be misconceived. There is no scale of reasonableness. There is no consideration of reasonableness. That is not the test. The test is it an agreement to reduce the limitation period or not? It's not whether it's an onerous requirement to comply. It's whether the provision has the effect of reducing the limitation period, thereby undermining the purpose of Article 123. It's black and white in my submission. Either it's an agreement which narrowly expressly reduces the limitation period, or it's any agreement which has that effect. My seventh submission is specifically in relation to this case. As an example, the engineer rejected the contractor's claims for time, not just on procedural grounds, but also substantive grounds, despite the fact that the contractor subsequently has been fined by the courts to be responsible for only 19 of the 325 days. So there's clearly concerns about the adequacy of those determinations. Parties should have the right to bring their dispute before the courts. That is the purpose of Article 123, to prohibit one party from restricting the other in bringing that claim. Those are all my submissions in relation to that point, the employer's objection in relation to that point. The employer's second submission is that a claim submitted to the engineer is not a claim for breach of contract. As such, Article 123 does not apply. I'll just take the court to D77. And looking at paragraph B here, which is, again, this is the contractor's skeleton. This is the contractor's responsive skeleton dealing with this point. And it's at subparagraph 1 and 2, which deals with this issue. Clause 3.5 provides that a party cannot challenge the issues which were the subject of an engineer's determination unless notice is provided. When these issues are concerned with EOT and additional payment, as in this case, the effect is that if no notice is submitted in time, the contractor is debarred from bringing a claim for breach of contract by the employer for failing to pay prolongation costs, for example, or for any other sums which have been offset by the application of liquidated damages. So it still does concern a limitation on the ability to bring a claim for breach of contract. Those are all my submissions on ground 2, unless the court has any questions. My lord, I think you're on mute.
Nothing from me. Yeah,
I have a question, unless anyone else has one first. Can you refer me again to clause 3.5? What page is it?
It is, well, within my skeleton, it's at
D something.
D18.
Yeah. It occurred to me, I'm not sure this is the point that's been taken by the other party, but it occurred to me that if you read clause 3.5 carefully, it does not have the draconian effect which you are concerned about, or which the judge found. If you could take the second paragraph, the engineer shall give notice to both parties of each agreement or determination with supporting particulars. Now we're talking about determinations which might be, for example, variations and the like. Yeah, possibly extended.
And/or determinations of an EOT claim, as in this case.
Yes, but it then goes on to say each party shall give effect to each agreement or determination unless one of them notifies of dissatisfaction within 14 days. And then the third point is either party may then refer the dispute to be settled in accordance with clause 20. It seemed to me arguable, and I'd welcome your view on this, that all it's saying is when you get a decision, if you don't like it, you've got to complain within 14 days or just get on and comply with it. Yeah. But then
that was the judge's finding.
Well, yes, but that is only to make the contract work. You get on with it, but it doesn't stop you at the end of the day raising your concerns. So in other words, the last sentence allows you to bring your complaint about the decision, regardless of whether or not you have complained at the time. You bring it to be sorted out in the final accounting between the parties. So 3.5 doesn't bar you from taking the point in the ultimate litigation. It simply stops you holding up the contract works if you haven't complained within 14 days.
Well, indeed, my lord, that interpretation does seem to be possible from the clause itself, and it is one that the contractor would rely upon, subject to the court's determination on that point. Indeed, such a finding would, of course, negate the judge's findings that the contract.
Yeah. Is there any case law on the meaning of 3.5?
I think this is a bespoke. I'm not sure. I think this part might be a bespoke part to FIDIC 3 FIDIC, but I'll just have a quick look.
My lord, can I ask this? The original text is at C28.
C28.
That's the original text, which is quite different and is in accordance with my lord's suggestion just now. C144 is the party's bespoke amendment, and as my learned friend indicated, there is not case law on it because it is a bespoke amendment.
C28 and then C144.
Yes, my lord.
Yes, I see. Give me a second, can you? Yeah. Okay. Well, I'll look at that later, but certainly it's a point I would like help on from both parties.
Indeed, well, my lord, it's a, as my lord has indicated, it's a possible construction of clause 3.5, which is obviously not the construction that the judge at first instance had adopted. In my submission, it's a construction which would be fairer and indeed in commercial interests of construction parties as or parties to construction contracts, as otherwise it would have a seriously inhibiting effect and not be helpful for wider commercial purposes. As such, and as such, was not intended by the contractor. Indeed, in the first instance proceedings, it was confirmed by the contractor's witness that no notice of dissatisfaction had been sent following the engineer's determinations. Had such draconian effect been understood by the parties, it would have been very simple to have served such a notice. Very, very simple. And given the fact that these determinations were completely rejected all of the contractor's claims, it would have been a very poor decision for the contractor to have not submitted a notice in that time, had that been the draconian intention of the clause, or had that been understood to be the draconian intention of the clause. As such, in my submission, that's not what the parties appear to have intended. And indeed, objectively, is not what they would have intended, having regard to the commercial purposes of such an agreement. I'll let my learned friend address that point further within his submissions, and I'll perhaps come back to it later on. But I appreciate my lord for raising that point. Are there any other comments from the court in relation to ground 2?
Not from me, thank you.
I'm grateful. So ground 4 relates to the judge's findings in respect of the interpretation of clause 20.1, and in particular, the period for when a party is required to submit us. Yes, so one final submission in relation to ground 2, my apologies, and it's just something that's come to me in looking at ground 4. As I will come on to in relation to ground 4, it is a common law principle that in relation to parts of a contract that relate to possible granting of EOT or the NEOT mechanism, they are to be construed strictly in favour of a contractor. As such, where there are 2 possible different interpretations, and indeed it appears that that is possibly the case with clause 3.5, the interpretation that is more favourable to the contractor is required to be preferred, having regard to the common law position on granting of EOT. And I'll come on to that common law in ground 4. Ground 4.
You're going to give us the authority. You're going to give us the authority for that proposition, are you?
I am, yes, my lord.
Okay.
Yes, I'll be dealing with that within ground 4. Ground 4 relates to the judge's findings in respect of the interpretation of clause 20.1, and in particular the period when a party is required to submit its delay notice, having regard to the 28-day condition precedent to EOT. Now the judge found, and this is at B65. So I'm looking at paragraph, this is the top paragraph here, the bottom end of paragraph 53. And he disagrees, this is a paragraph where he disagrees with the submissions in relation to the case of Obriscon. And he states here, in my opinion, the effect of the first paragraph of subclause 20.1 is if a contractor is aware or ought to have been aware of an event or circumstance that could give rise to an EOT claim, he must give notice of that event or circumstance within 28 days of being so aware. That is when the period starts. Now, the contractor contends, in reliance on the judgment of the English TCC judgment of Aikenhead J in Obriscon, which considered the identical provision, an unamended Article 20.1 from FIDIC 1999, and found that the 28-day period did not commence until critical delay in respect of that event starts. The contractor's position is already set out at paragraph 74 to 79 of its first appeal skeleton, and I have 6 submissions in respect of this ground. My first submission, so this is in relation to the interpretation of clause 20.1, or the correct interpretation. The first submission is that on a textual analysis, clause 20.1, when read with clause 8.4, provides that a contractor is only entitled to submit notice when...
You've gone off.
Pardon, my lord?
You stopped, you suddenly went silent.
Oh, apologies. Am I back on?
Yeah.
Grateful.
Can you please repeat the last part?
Okay, so on a textual analysis, clause 20.1, when read with clause 8.4, provides that a contractor is only entitled to submit notice when delay actually starts. This point is the one made by Aikenhead J in Obriscon. So if I could take the court to D21, this is the contractor's first skeleton, and the relevant extract from Aikenhead J's judgment is set out at paragraph 78, paragraph 3.312. And if we look halfway down, we can see that Aikenhead J says regards as in the bold at the end of the first bold section, regard in the context of extension of time at least must be had to clause 8.4. And then clause 8.4, and this part of clause 8.4 is the same as in this case. The contractor is entitled to EOT if completion is or will be delayed by the following causes. Aikenhead J then states, entitlement thus arises if and to the extent completion is or will be delayed by the various events. This suggests that EOT can either be claimed when it is clear there will be a delay, or when the delay has at least started to be incurred. If we scroll down to the...
You've gone silent again.
Am I still there? Sorry, am I back?
We missed a bit. You started saying we'll scroll down to something, and then you cut off.
Can we scroll down to the next page just above paragraph 79? So it says here, the wording in clause 8.4 is not is or will be, whichever is the earliest. So the interpretation of Aikenhead J on a textual analysis is that you can either claim EOT when there will be, you're only required to submit a notice when you will be delayed, or when you are actually delayed. So if you scroll down to paragraph 79A, the points or the way that this is dealt with is all set out there. So subparagraph I, pursuant to clause 8.4, Aikenhead J analyses MESC is entitled to EOT if it is or will be. As such, you're entitled to submit a notice when it knows that it will be, or when it is actually delayed, and it's not, whichever is the earliest. Pursuant to clause 20.1, you're required to submit a notice when you're aware or should be aware of the event or circumstance which entitles the contractor to EOT, and an event or circumstance either entitles MESC to an EOT when it will be delayed, or when it is actually delayed. So it could be either of the two. And as such, a contractor is only required to submit a notice at the latest when it is actually delayed by the event or circumstance.
What's the purpose of having the will be delayed then? Because that's always going to be prior to actually delay. Why not just say must give a notice, whatever period after actual delay?
I suspect it indicates to the contractor that is a time when they can submit notice at an earlier stage, because I think the contractor isn't required. So the contractor is only to submit notice when they believe that there is an event or circumstance which will give them which will grant them an EOT. They're not to submit a notice whenever there's a possible delay, but they don't actually think it will lead. Sorry, there's a possible issue, but they don't actually think it will lead to delay. So it grants the contractor a possibility of submitting it earlier if it so chooses. The contractor is not supposed to be sending notices for any possible delay or circumstance. They're only to submit a notice when they believe that there will be a circumstance which gives them EOT. And in relation to those circumstances, it's either is or will be delayed. So it can either be one of the two.
In the circumstances of the facts of this case, how can you remind me? How do you relate to the facts of this case?
Well, in the facts of this case, as I'm going to come on to this in a moment, once I've finished this ground, but in my submission, notices were sent in relation to each of these delays within the required period for when critical delay started for each of the critical delay events. The judge found, or the judge rejected, MESC's submission in relation to the period that was required to be examined for such notices, and as such found that notices were not served within that period or within the required period. And so my second point, and it's related to this point, is that the contract, my understanding is that the employer within their first skeleton, I believe, and I'll just direct, or possibly their second skeleton, so this is the employer's skeleton, which suggests, I think it's their supplementary skeleton. And paragraph 60 says here, properly analysed, there's no departure between the approach of this court and that of the High Court in England in Obrascon. Paragraph 62, it's alleged that the judge in Obrascon did not suggest that the contractor, aware of both the delay event and that it was likely to cause delay, was entitled to wait until the delay actually started before the obligation to give notice was required. And respectfully, I think that that's incorrect. If we go to E407, which is the judgment of Aikenhead J in this case, and if we look at the final sentence of the bottom paragraph, an EOT can either be claimed when it is clear there will be delay or when delay is at least started. And then an example is given. So if we scroll down to E408, and then we look at this hypothetical example, variation issued on the 1st of June, at the time of the instruction, that part of the carriageway is not on a critical path. So it's foreseeable that it will extend the period, but not that it will delay the work. And then paragraph D, by the time the dual carriageway is started in October, it is only then clear that the works overall will be delayed by the variation. So in October, it's clear that there will be a future delay by this variation. However, the delay does not actually start until November. Aikenhead J clarifies in paragraph E, notice for the purposes of clause 20.1 is not actually required until there is actually delay in November, although the contractor can give notice with impunity when it believes that it will be delayed. So that deals with my lord's point to a certain extent, that it can give delay earlier on, it can give notice earlier on if it wishes so, but it does not actually need to give notice until the delay is actually started. My third submission, and it's perhaps the most significant submission in relation to this issue, and it also relates to ground 1 and ground 2, is that extension of time provisions are required to be construed in favour of a contractor, and my submission that this is a well understood provision of common law. In this case, it's common ground that there are two possible different interpretations of article or clause 20.1 and clause 8.4. as to when notice is required. One of those interpretations, which I contend for, is more generous to the contractor. And in my submission, it's, as I stated, it's a well understood principle of common law that EOT provisions are to be construed in favour of a contractor, and that's because of the potentially harsh effects, namely the imposition of liquidated damages of any failure to comply. This partly comes out of the prevention principle, which I'll come to later. So this point was already discussed within Aikenhead J's judgment to a certain extent. If we scroll up to paragraph 312 at E407, and he says, I can see no reason why this clause should be construed strictly against a contractor, and can see reason why it should be construed reasonably broadly, given its serious effect on what could otherwise be good claims, for instance, for breach of contract by the employer. But this was also dealt with in various other authorities. I'm just going to take the court to E445. This is the case of Peake and McKinney, which deals with or considers the prevention principle in particular. But it's if we look at the bottom paragraph, it states here, the liquidated damages and extension of time clauses in printed forms of contract must be constricted strictly contra proferentem. This principle is also set out in other authorities, in particular Multiplex and Honeywell, which is the case that the employer relies upon in relation to the prevention principle. So this is at E628, and I'm directing the court then, directed everyone there, so E628, and I'm looking at the top left-hand part, Roman numeral 3, and it states here, insofar as the EOT extension of time clause is ambiguous, it should be construed in favour of the contractor. Of course, the contractor resists the obiter comment in Multiplex as far as they concern the prevention principle otherwise, which I'll come on to. But this illustrates that this contra proferentem requirement is a relatively well-versed issue in relation to EOT provisions. Finally, in relation to this point, under Article 54 of DIFT contract law, which is E594, and at the very bottom there, if contract terms supplied by one party are unclear, an interpretation against that party is to be preferred. Now, that's obviously a standard interpretation point, not specific to the EOT mechanism, but it's submitted, it is also relevant. In this case, the contract terms were drafted by the employer, as I understand it, and as such, they're to be construed in favour of the contractor.
Which section was that?
Sorry, which?
The last reference you gave us on E594.
E594, Article 54.
54, okay, fine, thanks.
At the bottom there. So that's my third submission in relation to ground 4. Now, fourthly, on a contextual analysis, having regard to the commercial purpose of the clause and the contracts, in my submission, Aikenhead J's interpretation should be preferred. The effect of Justice Field's interpretation is that a contractor would be required to provide notice for every event that they believe will give rise to future delay. Inevitably, many of these events will not transpire to actually cause delay. As such, this interpretation may require unnecessary notices to be sent and may not be helpful and increase costs. My fifth submission is that Justice Field's interpretation is much less certain and would lead to problems in assessing when a notice should be served. This is because it depends upon a contractor's subjective belief or knowledge as to when an event will cause delay in the future. That is in itself a much more difficult point in time to assess than when actual critical delay occurs. I.e., at what point should a contractor be aware of when something will cause future critical delay? In my submission, that is much more difficult to establish than simply establishing when the critical delay occurred. As such, it will complicate, Justice Field's interpretation will complicate when these notices should be sent, and indeed this is an important point for many parties moving forward, under which there would be less certainty. And my sixth submission is that Obrascon is it's not binding here, but it is a persuasive.
Sorry, we missed you. You were saying what? Obrascon is something.
Sorry, Obrascon is authoritative in the English courts. It's a ratio decidendi. I appreciate it's not binding here, but it is a persuasive TCC judgment. The employer itself relied upon this case within its closing submissions for a different point. The reference for that is at, I'm not going to go to it, but it's A211 at paragraph 31, if the court does want to look at that later. I have not personally seen any competing authorities suggesting a different interpretation for this standard term FIDIC to Obrascon. So in my submission, this court should align itself with the judgment in that case. So now I've dealt with, before I move on to the next point, which is going to be in terms of how those grounds affect the sums to be paid in this case. Are there any queries from the court in relation to my submissions there?
No.
Not from me, thank you.
Good.
So now I've dealt with the merits of all of those grounds on the legal merits. What appears to be one of the primary criticisms of the employer in relation to these grounds is what is the actual effect they'd have on the order if they were granted? What sums would be paid and what would happen? In particular, the contractor alleges that the employer alleges that the contractor had not identified the sources. How success in these grounds would affect the delay events within this claim. Now, that's already been dealt with a little bit in my supplemental skeleton, but I'll deal with it more now. I've already discussed ground one and conceded that this is a less important ground in terms of the actual findings of the judge, but there is a finding in relation to one of the delay events. And in particular, if the contract is not successful on this ground, it may prevent entitlement to other EOT if the employer were to later rely upon it. Ground two is much more important, because if the contractor fails on this or fails to overturn the judge's findings on clause 3.5, it's ultimately unlikely to be granted EOT in relation to most of its events. We'll have to do a bit of a dissection in relation to those afterwards, but I do concede that is a very important ground. However, if there is success on ground ground two, but not on ground four, there is a very small amount of days that might still be added, which would have in terms of prolongation costs, even if it didn't affect liquidated damages. But ground four is also very important, as it's on this basis that the judge refused to accept the contractor's submissions about notices, and as a result rejected most of the delay events, or the EOTs for delay events for that were claimed in this case. If I go to B64, and if we look at paragraph 52, this says, on this basis, MES contends notice was given on the following critical delay events. This is an extract from the contractor's closing submissions. And then scrolling down, we see the paragraph 53, which I've already referred to, in which the judge rejects the contractor's argument in relation to Obrascon, and finds that there's a different period required to be examined for when notices are to be provided. Then, importantly, at paragraph 54, the judge says, it follows that I reject MESC's contention in its closing submissions that due notice was given for the critical delay events set out above. So it is because of the judge's rejection of the contractor's argument in reliance on Obrascon that it ignored effectively the contractor's submissions about when notice was required, or when notice was provided in relation to the critical delay events. As such, I submit that if the contractor is successful in this ground in relation to Obrascon, the judge's finding that MESC's contentions that due notice was given in relation to critical delay events will also need to be set aside, and there will need to be a fresh review of whether the contractor had submitted notice within the required period for each of the critical delay events. This would necessarily be the case, in fact, because as a different period, as the court would be saying that there's a different period required to be examined for when the contractor was required to submit notice, a different period for, or different notices would have to be reviewed. As such, there would, in any event, need to be a fresh review. It is my understanding that the employer also refers to the possible need for a fresh review within their initial skeleton or a further factual inquiry. So if necessary, and if this court did not consider that it was in a position to undertake this fresh review at this stage, this could be dealt with in submissions afterwards or sent back to the TCD First Instance Court. However, in my submission, contained within this hearing bundle are notices for each of the critical delay events found to have caused critical delay, which I'll come on to. I'm going to discuss the critical delay events and these notices, as even if the court did not subsequently wish to undertake this fresh review today, it's necessary to just counter the employer's argument that success on ground 4 would make no difference. So before I do this, to note, sorry, I think I've already spoken about ground 2 and 4. So firstly, what's required for a notice? Under clause 20.1, so go to C75. This is the contract itself. And it's the first paragraph of 20.1. If considered entitled to an EOT, the contractor shall give notice to the engineer describing the event or circumstance giving rise to the claim. It doesn't need to self-reference that it's a clause 20.1 notice. It just needs to describe the event or circumstance giving rise to the delay. So what were the critical delay events? These have already been referenced within my closing submissions, which have been referenced within the supplementary skeleton and within the judge's judgment, which I just took the court to. The judge found, so I'm going to B128, and this is at paragraph 208. The judge said, in short, I accept the conclusion of Mr. Singhal that the critical delays that occurred during the currency of the project totaled 325, 306 to be assigned to Panther, 90 to MESC. In effect, the judge agreed with Mr. Singhal's evidence in his first report, and as such, the events that Mr. Singhal had identified as causing critical delay within that report. Within Mr. Singhal's first report, there are 7 delay events which Mr. Singhal found to have caused critical delay, for which the contractor would be entitled to EOT. These were all independently discussed within the contractor's trial closing submissions. But I'll just briefly review Mr. Singhal's first report to clarify these critical delays and for when the critical delay started for each, and then whether notice was sent for each of these. So if we go to F304, and at paragraph 176, you can see the way that this is dealt with the different windows. So window 1, there's 7 days of delay, 5 to the claimant, Panther, the employer. Window 2, 149 days of critical delay, all to the employer. Window 3, 89 days, 72 of which to the employer, and window 4, 80 days, all of which to the employer. If we go, so now looking at these windows itself, if we go to F283, this is the first window. And if we're looking at paragraph 91, I understand that delayed issuance of civil IFC drawings from the claimant might have restricted the defendant from executing the excavation works. And then halfway through, therefore, in my opinion, delay in completion of substructure works for 5 days is beyond the contractor's control. So the 5 days is for civil IFC drawings. That's what the critical delay was in window 1. In relation to this, if we go to, page, sorry, 1 second. So if we're on the same page, we can see paragraph 89, DE2, delayed receipt of civil IFC drawings. We can see that that finishes on the 26th of October. So 5 days before the 26th of October would be the 21st of October. As such, the notice would be required within 28 days of the 21st of October, as that's when the critical delay started. If we go to G22, this is the notice that the contractor relies upon. It's dated the 14th of September, so before the critical delay started. Please be informed that we are still awaiting IFC drawings. We are not responsible. Well, I think it's supposed to be responsible for any delay due to this event. So that's window one. I'm just going to briefly run through the other windows to just, and as I say, the main point of this is to demonstrate that there is an effect if the court does agree with the contractor's ground 4 and or ground 2. Now, if, as I said, if the court requires further written submissions on this, because I know it is not straightforward looking at an expert report in this detail, in this time period, then that can be provided afterwards if necessary, or if necessary, it can be remitted to the first instance court. But the purpose of this is to demonstrate that there is an effect. And as stated, this was dealt with to a certain extent in the skeletons by referencing the critical delay events. So the window 2 is, if we go to F290, so this is window 2, and at paragraph 124, we can see 149 days, and Mr. Singhal says at 123, based on the opinions expressed above, I understand the above mentioned delay events restricted the defendant from executing the superstructure works, which led to a delay of 149 days. So he says the above mentioned delay events. So if we scroll up to the page above F289, and looking at paragraph 116 in particular, and I'll be referring to this paragraph frequently. This summarizes the possible delay events within this window. And then within this window, at paragraph 118 to 121, Mr. Singhal assesses the events which he considered caused critical delay. At paragraph 118, he refers to 118 and 119, he refers to post-tension drawings for the podium slab. And that relates to delay event 4. So that's it's Roman numeral I at 116. And then at paragraph 120, he says typical post-tension drawings for other floors delayed for 19 days from 28th of March. So that's typical post-tension drawings. Now this relates to delay event 5, which is Roman numeral 2 in 116. He says delay due to post-tension drawings for typical floor slab 19. Paragraph 121, he refers to at the bottom there, delays in finalizing structural designs of the 12th floor and roof, and also so 113 days and then 106 days. So you can see where that relates to, which are Roman numeral 5 and 6, which is DE8, 113 days, which is structural designs for the 12th floor, and delay event 12, which is 106, which is designs for the roof floor. So those are the delay events in window 2, which Mr. Singhal considered caused critical delay. Now I know that those add up to more days than was found for this window, so I think that there's some concurrent overlap in relation to a combination of these events, but those were the events found to cause critical delay. Therefore, the contractor must prove that notice was sent in relation to when critical delay started for each of these events. In relation to delay event 4, therefore, if we're looking at Roman numeral 1, the delay goes for 34 days until the 28th of January. So, and sorry, if you look at paragraph 118, 119, the judge, he said, Mr. Singhal says his opinion was that caused 26 days of delay. So 26 days before the 28th of January is the 2nd of January. As such, the contractor was required to submit notice within 28 days of the 2nd of January. If we go to G23, this is the notice which was provided on the 18th of January, in which the podium post-tension works were referred to. You can see here at the bottom, we keep our rights contractually, cost and time impact. So this would be a sufficient notice for clause 20.1. Going back to the next delay event, which is F289. So back to that page again, delay event 5. Now this was to end on the 28th of March, as such 19 days. And so you had to submit a delay event from the 8th of March, within 28 days of the 9th of March on the interpretation from Obrascond. And if we go to G33, this is a notice on the 3rd of April, which is just within 28 days of the 9th of March. And again, it references typical floor drawings, and in my submission, this notice itself actually does refer to clause 20.1, although not all of them do. As such, it's sufficient to comply. Going back to F289. And looking at delay event 8, which is in Roman numeral 5, the delay of 113 days. Now that starts on the 1st of July. So you had to submit a notice within 28 days of the 1st of July. So by the 28th, 29th of July, in relation to this is delay and finalization of 12th floor structural design. Now the notice in this case is G34, or the first notice at least, which is on the 24th of April 2018. So that's well before the period required. And again, it refers to this final architectural and structural layout for roof and top roof. So roof, I think, is the 12th floor, and top roof is the 12th floor. There is also a further notice in relation to this item, which is at G37, which is on the 19th of July. So that would still be within time for this event. And you can see at paragraph 4 there, final structural and architectural drawings for 12th floor and top roof, delay notification on its face. And again, on the second page of that, this provides a notice pursuant to clause 20.1. So that's delay event 8. Delay event 12 is actually the contractor relies upon these same two notices for delay event 12 as well, because it's the same general point, which is so it's delay event 8 relates to the 12th floor, whereas delay event 12 relates to the roof, the top roof. So these notices serve purpose for notice in relation to both of these delay events, because they're both delayed drawings for these two different floors. If we go to F289 and paragraph 116 and then subparagraph VI, that's delay of final architectural and structural layout, and so that's from the 13th of August. So notices had to be before the 13th of August. As stated, we rely upon those two notices that were already sent in April and July, so that would be within time. In relation to window 3, so that's window 2 done. In relation to window 3, if I go to F295, this clarifies paragraph 144, 89 days of critical delay, 72 to the claimant. Okay. And if we go to if we scroll up a page, and he says, sorry, Mr. Singhal says, based on the above, that's what his opinion was. And if we scroll up, we can see at paragraph 139, I noted the claimant had submitted its blockwork drawings for the roof on the 3rd of July. the approval of the same was delayed until the 27th of December. So he states that it's the block work drawings which effectively have caused this delay. And if we go to F304, this demonstrates that window 3 starts on the 31st of December. So the 72 days of critical delay start on the 31st of December in relation to this window. Because I think, as I say, it's the drawings weren't given until the 27th of December, but actually the critical delay in this window doesn't start until the 31st. So that's when the delay starts. So it needs to be within 28 days of that. And actually, the contractor relies upon those same two notices, G34 and G37. So just to direct, because this is the same structural or it's the same issue, which is drawings, although this relates to block work. It's the same issue with delayed drawings that have been provided. And finally, in relation to window 4, if we go to F303, and paragraph 1, so if we scroll down to the bottom, 174, he finds that there's 80 days of critical delay within this window due to above observations. And his above observation is, if we scroll up to page 302, paragraph 168, he says, I'm of the opinion that the critical delay in the completion of the aluminium work is beyond the defendant's control on account of the delay to the late finalisation of the balustrade design. So it's the late finalisation of the balustrade design that caused the delay in this case. And if we scroll up again to page 301, we can see a paragraph 162 where the various different possible delay events for this window are cited, and the delay in finalisation of balustrade design is referred to at item Roman numeral 1, and that finishes on the 27th of August. So that finishes on the 27th of August. 27th of August is the 8th of June.
We lost there for a few seconds.
Sorry. Okay, so the 80 days before the 27th of August is the 8th of June. So on the findings from Obprascon, the claimant would be required to submit notice within 28 days of the 8th of June. The notice that the contractor relies upon in this case is G60, and that's at this is a notice that was sent on the 1st of July, which references this. However, there are other notices within the bundle which forward letters from the contractor's subcontractor before this date in relation to this same issue. But in any event, it's submitted that this would be submitted within time. Now, as stated, I appreciate some of that was quite technical, and I know my learned friend will have points on that and may need some time to deal with it. But to the extent that is necessary, that could be dealt with in further written closings, but or it could be dealt with or remitted. But the point I've gone through that is on the claimant's case, there is a notice within relation to each of these periods for critical delay, and as such, on the claimant's case, if we are successful on the contractor's case, if we are successful on grounds 1, 2, and 4, we would be entitled to the full 306 days extension. Does the court have any questions in relation to that?
No, not for me. Thank you.
My lord, I hate to interrupt, but may I just make a very, very, very short interjection? My learned friend suggested I may have some points to make about that. I personally found my learned friend's explanation of the notices he relied on and the timings quite impossible to follow, it not having been trailed in any written document. We've had two very full skeleton arguments. In both of them, we have made the point at length that no factual finding by the judge is challenged, that the judge made detailed findings as to when notices were given, and the only reference my learned friend made was to the points made in his closing submission, a brief paragraph in his closing submission, which bears absolutely no relation to the very detailed factual evidence, documentary evidence, and expert evidence, all of which we on the employer's side are hearing about for the purpose of this appeal for the first time. So I don't want to interrupt my learned friend's flow, but just for the record, we do strongly object to this sort of factual analysis, let alone the possibility of yet further written submissions or response. Obviously, I've had absolutely no opportunity to take instructions on this sort of minutiae. So I'll leave it at that. Thank you, my lord.
The only, so my lord, my point in response is the bundle to this hearing was agreed about 10 days, or sorry, it's only over a week ago, and the reliance upon all of these notices was provided over 10 days ago by the appellant. So the provision of these notices, which is contained within the bundle, and there's not many of them, there's only about 10 different documents which have been referenced. So there's 10 documents which were provided over 10 days ago. And the critical delay events that the contractor relies upon have not changed. They're the same critical delay events that were relied upon within the contractor's closing submissions in the first instance proceedings, and indeed within the appeal grounds or the appeal supplementary skeleton. Whilst I appreciate that the detail of all of these specific notices and delay and the critical delay in relation to each of those was not lettered out in skeleton arguments, and there are detailed skeleton arguments in this case. It's not the
Mr. Burrell, for the benefit of the court, judges as well, it would help if you summarize what you're submitting the last 10 minutes or 15 minutes into a one-pager or something, one-pager, and cross-reference to the relevant pages, so we could see the whole scenario, the whole picture, instead of having to open one by one. Is that possible?
That can be done, my lord. I can do that within a week of the hearing.
And you can pass one copy to your Mr. Mott, and he could have, the picture of the whole thing, as I say, in one page or two page.
Yes, my lord.
I find it difficult to follow page by page as well what you submitted. They're quite detailed.
I do understand, my lord. And yes, indeed, I can do that within a week. And of course, Mr. Mott will want to have an opportunity to respond to that. As stated, though, it is common for parties to expand upon their submissions in oral evidence, in oral argument, which is what I've done today. And as stated, these matters were already within the bundle for some time. But indeed, the point that my lord makes would adequately perhaps deal with that point in terms of being able to set it out in writing, and then an opportunity for my learned friend to respond.
Mr. Burrell, I'm not quite sure why you need a week. You've given details.
I can do it within. I can do it within days, my lord. I can do it by the end of this week.
By tomorrow morning.
By tomorrow morning, yes, my lord.
Actually, you could. You have your junior counsels and people, clerks helping you. They can. You can. It's not so difficult. I was about to say the same thing.
I can certainly do it by the end of today, my lord.
Sure.
Yeah, I can do it by the end of today. Absolutely.
Yes.
Okay, so the next submission is in relation to ground 5. I just want to keep an eye on my timings. So, okay. Ground 5 concerns the application of the prevention principle, and I will spend. I've got 6 submissions in relation to this. And I just wanted to remind the court that in this case, we're dealing with a situation where the employer has been found responsible for 94% of the delay, yet because of the contractor was found not to have provided notice in time, and as such, the contractor is in fact paying the employer. So if I go to my further skeleton argument, which is at I3, this details the development of the prevention principle in English law. And the point that arises from this is that this is a principle which is over 450 years old in common law and is rooted in consideration to fairness and justice, which is easy to understand. It's not fair to oblige a party to finish by an agreed date if it were prevented from doing so by the other party. If it does so, then time is set at large. Now, over the years, the authorities indicate that there's two routes in which parties can try and avoid the imposition of the prevention principle. The first route is contracting out, namely expressly agreeing that the contractor will accept employer delays and this will not affect time. I'll come on to that in a bit more detail shortly, but it comes from Dodd and Churton, and it requires very clear language. The second route is that the parties can create EOT mechanisms which allow parties to disentangle employer delay from contractor delay and allow EOT to be given for employer delay. So the prevention principle is not contracted out of as such, but is circumvented. It doesn't come into being because a contractor is not being held responsible for the employer prevention. So if we scroll down to my, I think there's already submission set out there, but if we scroll down to my I6, so page 6 of this document. Having regard to the development of the two routes, and I refer to paragraph 20 of this document, there's two routes which allow avoidance of the prevention principle, either express agreement contracting out of it, as it were, or an adequate EOT mechanism. And into my submission, the case of Gaymark is merely an affirmation of this orthodoxy in terms of these two routes. An agreement, and this is at paragraph 21, an agreement that a party or a contractor is entitled or is not entitled to EOT in circumstances of employer prevention because they've failed to comply with the notification commission precedent is not an express agreement that the contractor would accept responsibility for employer delays in the sufficient clarity of words that is required, which I'll come on to. In relation to the second route, this is much clearer. It's not an EOT mechanism which allows the circumvention of the prevention principle, because if there is a circumstance where an employer causes a delay and the contractor doesn't submit notice, then the contractor is in that circumstance being held liable for the employer delay. And as such, the prevention principle is engaged and the EOT mechanism doesn't work. It's not been drafted in the right way to allow for all employer caused delay to be granted an extension for. So the prevention principle isn't circumvented. So an agreement in relation to notification conditions precedent is not a second route circumvention. So in my submission, the question for this court, or one of the main questions for this court, is whether it is a first route, whether clause 20.1 is a clear agreement that the contractor is taking on the risks of the employer prevention. Now, I've got two submissions in relation to this. Some of these arise from the well-developed articles of both Tony Marshall and Professor Doug Jones, which are within the bundle, if the court wishes to look at those at a later stage. But my main submission is that they are not part of the first route. And the first submission in relation to this is to stress the importance of the prevention principle and the requirement that it's not contracted out of lightly. As stated already, the prevention principle has a long history and is grounded in fairness. Now, it's an important principle which therefore requires very specific drafting if it is sought to be contracted out of or circumvented. Now, that's because allowing an employer to directly financially benefit from its own act of prevention is an extraordinary position, and one which is not only inconsistent with the rationale of the prevention principle, but contrary to ordinary norms of contractual interpretation. As such, whilst it's accepted that this result can be achieved if the parties so desire, in order to contract out of the prevention principle to this degree and to achieve such a big displacement of risk to the employer, to the contractor, this requires very clear language to this effect. Now, this is confirmed by the case of Dodd and Churton, which is referenced within my skeleton. It's at I4 at paragraph 13, if you want to scroll up. So it's paragraph 13 and it's the bit in italics. It would require very clear language to show that a man had undertaken a responsibility which few would undertake with their eyes open. So a comparison with this requirement or for very clear language can be drawn with the common law doctrine of penalties. Penalties cannot be contracted out of, or you cannot contract out to say that you're allowed to have a penalty. The prevention principle is similar, but you can contract out of it, but only if there is very, very clear language showing an undertaking of a responsibility which few would undertake with their eyes open. So my second submission is that the agreement within clause 20 is not very clear language, which few would agree to with their eyes open. The clause simply provides that if no notice is provided, there will be no EOT. However, on its face, it's not clear from that clause that the contractor is agreeing to be responsible for employer-caused delay if it did not submit that notice. That's in part because clause 20.1 notice requirements apply to both neutral delay events, e.g. bad weather, but also employer delay events. They apply to both. As such, it's any event which a contractor is entitled to EOT. By contrast, to give an example of what would be considered a clear clause, would be to say the contractor assumes the risk and liability for all delay caused by the employer and agrees to pay liquidated damages for such delay caused by the employer, except in circumstances where it applies for extension of time in accordance with the notice requirements and time bars in the contract. Now, the question is, how many contractors would accept such a provision? Very few is the submission, and that's exactly the point. The first route requires very clear language, immediately obvious to contractors that they are taking on this risk of the employer's delay, which is submitted as a risk few would agree to. That appears to be concurred within Doug Jones's article, and the reference for the court, although I'm not going to go to it, is E112. An ordinary contractor needs to be fully aware with their eyes open that that's a risk they're signing on for. Clause 20 doesn't meet that hurdle because it's not clear to an ordinary contractor that they are explicitly accepting liability for employer delay if they fail to submit a notice. It's just not that obvious. My third submission is to address the major criticisms of games. Sorry, my lord.
Can I just ask? Sometimes these things seem more skewed because we talk in terms of a certain principle which is not engaged or is engaged and so on. But I wonder, on one view, if you look at 20.1, it simply bars a claim for an extension of time if notice is not given within 28 days. And that failure to get an extension of time means you don't get prolongation costs either, I think.
Yes.
But it doesn't follow automatically that the failure to get an extension of time opens the door for the employer to get damages for delay, because you can still say at that stage of the argument, but you can't claim damages because it's your own fault. So can one not separate out the extension of time part of it from the employer seeking damages for delay, and simply say, well, you don't get your extension of time, it's your fault, you didn't give a notice, and you don't get prolongation costs because of that. That's your fault for not giving a notice. But the general rule applies nonetheless, that an employer can't take advantage of his own breach and claim damages.
Well, my lord, you've rather sort of a foreshadowed an argument I was about to exactly come on to. I think it is my understanding that the current prevention principle, in the way that it currently operates, it is not that case. But it is my submission that there is an alternative formulation of the prevention principle, as articulated by my lord just there, which would allow those two things to be separated. Currently, the prevention principle attaches to the time for completion, and as such, that also applies to liquidated damages. Therefore, if EOT is not extended, so the prevention principle under orthodoxy, or under the current formulation, is that it applies to the date for completion. As such, if no EOT is granted, then liquidated damages run for that date. But there is a possible alternative formulation which is posited within Doug Jones's article, and which is relied upon by the contractor in this case, which is that this law could be reformulated, and it would be better if it was reformulated, in that it doesn't attach to the date for completion, but it attaches instead to the remedy. It attaches to liquidated damages. So instead of it meaning that time is set at large, the date is still there, and indeed a contractor is not allowed to claim for prolongation for that. So there's still some jeopardy from not complying with the EOT notification provisions, but instead the prevention principle attaches to the remedy, namely the liquidated damages, and that deals with the unfairness of an employer being directly financially benefiting from their own acts of prevention. That is in effect the contractor's ground 6, which I'm going to come on to in a little bit, although ground 6 was formulated in terms of good faith, but it's a similar provision. But yes, I'll address that in a little bit more detail in a moment. But yes, my lord.
But you don't need to go into ground 6 relies upon various articles of DIFC law. You don't need
Correct.
to go in order to and isn't part of the problem that we call it a prevention principle? Really, it's just an application of the rule. You can't take advantage of your own breach.
Yes, that indeed, yes.
Once you go back to the basics, then the solution is really quite straightforward, isn't it? And you don't. It's only once you call it a principle that you then have to modify a principle, and if you don't elevate it that high in the first place, you're much better off.
Well, indeed, my lord, that is one of the contractor's submissions in relation to this. The prevention principle, as it's commonly understood, as stated, attaches to the date for completion, but there is a reformulation of it, which my lord just touched upon, which would be to go back to the original provision, which is that you're not allowed to take advantage of your own breach, which a reformulated prevention principle, as posited by Doug Jones in particular, would allow if it attached to the remedy, namely liquidated damages, rather than the date itself. And as such, associated with both the Gaymark case and multiplex case. Ground 6 has stated it is posited on good faith, or the requirement to act in good faith under DIFC contract law, but the request was the same, namely that the date doesn't change, but simply that an employer is not allowed to pursue liquidated damages for delay which they had caused themselves. That's exactly the same point. It's just premised on good faith under DIFC law, and that's effectively the same point. Now, it's submitted that the DIFC is a forward-thinking jurisdiction, wants to develop the best and well-thought-out law, and as such, the reformulated prevention principle in this regard, attaching to LDs but not to the date, would deal with a lot of the criticisms of either Gaymark and multiplex as stated, and would be a logical approach moving forwards. It is also so I'm making my submissions under ground 6 now effectively, but it is also having regard to the provisions of DIFC law, it is particularly apt for this jurisdiction, in particular having regard to the fact that good faith is enshrined within DIFC law, which is different to other jurisdictions, and so that the correlation with good faith and the arguments already made under ground 6 would support this reformulated prevention principle, but also Article 122, which allows the court to adjust liquidated damages if they're disproportionate. Again, this is in relation to to a general principle rather than the actual discretion of the court under 122, which is a different point. So yeah, but my lord, that is in fact exactly the contractor's argument in relation to a combination of some of ground 5 and ground 6. Just to briefly backtrack, sorry, I just want to, just so I've made the submissions in particular, but indeed, that is in fact the contractor's submission for a large part of it. Going back to the conventional prevention principle and just dealing with some of the criticisms of it. One of the criticisms of Gaymark is that doesn't have sufficient regard for party autonomy. As stated, that doesn't matter because you're only looking at the first route, which is that you need to have very clear words, and it doesn't meet that test. The second criticism is often that there's benefit to the notice requirements, and as such, this benefit outweighs circumventing setting time at large for failure to comply. This is an argument of causation, in effect. If a contractor fails to comply with a notice, it is suggested that it is this failure to provide the notice that's the cause of the delay.
Sorry, Mr. Burrell, sorry to interrupt you.
Yes.
This contracting out one you just submitted me. What did the judge of first instance say on your submission on this point in his judgment?
This specific point.
Yes.
I don't think was made. It was the judge didn't make a finding on this. Gaymark was in the first instance decision. It was the contractor simply relied upon the position in Gaymark. The further developed legal points, which I've been referring to, weren't dealt with within the first instance case.
Oh, I see. Okay. And understand. Okay, thank you.
Thank you, my lord. But it's so just in relation to this causation. In my submission, this is not a useful or a good criticism, or the fact that the delay event can be investigated. Now, the example that's often given is that an employer gives instructions in ignorance of delay, whilst the contract has knowledge of this. But what happens in situations where the employer is aware of their actions or the ramifications of their variation actions? Should they still be allowed to rely upon the failure to comply with notice? In effect, there's an element of knowledge, which is not, introducing an element of knowledge is not helpful, partly because the prevention principle is too blunt, but also the underlying rationale of the prevention principle is to stop the employer preventing the contractor with the one hand and then punishing it with the other. As such, questions of fault and knowledge aren't applicable. Also, this subverts ordinary principles of causation. To treat employer delay as a result of a contractor's failure to provide notice is erroneous. Any relevant delay is set in motion by the employer in relation to this context, not the contractor. So how can a contractor be liable to pay damages for one breach, i.e. a failure to complete on time, if it's actually committing a different breach, failure to deliver notice, if indeed that's a breach at all? Third, whilst it's accepted that there's some benefit to providing a notice, it's not of such importance to lead to the abolition or absolute imposition of liability for LDs for not providing it. Indeed, the reformulated prevention principle, which was just discussed, would deal with this to some extent, because there is still jeopardy for not providing notice because there's no prolongation costs. Finally, any benefit of notice provisions is not really that relevant, because the prevention principle bites if the employer is effectively benefiting from its own wrong. The prevention principle is so blunt that as soon as that happens, it comes in. So the regardless of the benefit of notice provisions, it doesn't affect the imposition of the prevention principle. And the third major criticism is that of Gaymark is that a contractor can disregard with impunity any provision making proper notice a condition precedent. Now, that's refuted for a variety of reasons, some of which come from Tony Marshall articles. To clarify, a contractor cannot set time at large if it disregards notice requirements for neutral delay, only employer delay. Second, it only benefits in the negative sense of not having to pay liquidated damages. And even if it is set at large, they would still be required to complete in reasonable time and pay general damages, which would be, in this case, significantly more than the original. And finally, in contrast, for the delaying employer, in contrast to the Gaymark approach, the multiplex approach provides not just impunity for the employer's breach to hinder completion, but a windfall profit in liquidated damages. So, having now dealt with the criticisms of Gaymark, or the main ones, the finding on prevention principle in this judgment, similar to multiplex, pays inadequate regard to the policy of the prevention principle and its role in ensuring fairness, which is to require that a contractor is not punished, and an employer is not rewarded for an employer breach. And that is more important or significant than any of the criticisms of Gaymark. I appreciate I'm running over a little bit, so I'm going to try and round up now very, very briefly. I've already dealt with the ground six to a large extent. But as stated, given good faith and the importance given to that under DIFC law, puts us closer towards Gaymark than it is in multiplex, and indeed the reformulated prevention principle as already stated. If the court does agree to set time at large in my submission, there isn't any need for new delay of evidence. This is already dealt with within my further supplemental skeleton, as set out in Hudson's, which is the provision referred to within there. In the great majority of cases, the original contractual date will be accepted as reasonable time, and that's then adjusted for any EOT which the contractor would have ordinarily been entitled to, which would be 306 days. So there's no need for new delay of evidence. It's just a question of assessing general damages for that remaining 19 days. Obviously, none of that is necessary, or none of the no general damage consideration for that is necessary if the contractor's ground 6 is accepted and there is a reformulated prevention principle attaching just to liquidated damages, not to the time for completion. I've already made the submissions in relation to that. Finally, in relation to the new ground in relation to Article 122, if I take the court to E614, and that's subparagraph 2. And this is a discretion that's being sought. Effectively, what's being requested is liquidated damages be adjusted because currently they are grossly excessive to the loss that's actually incurred. Liquidated damages are agreed as a genuine pre-estimate of loss. A daily figure was agreed in this case of 42,500 per day as a pre-estimate of the loss that the employer would suffer for every day. The contractor was found to have only caused 6% of the delay in this case, but they're currently liable for 100% of the liquidated damages. That is grossly excessive. It is submitted. As such, an adjustment of these LDs is requested, for which the contractor did actually cause. And finally, in relation to this, it's a provision I referred my learned friend to a couple of days ago, or indicated that I'd be relying upon, which is Article 15 of the DIFC Law of Damages and Remedies. It's not within the bundle, but I'll read it out, which says, where the loss is due in part to an act or omission of the aggrieved party or to another event as to which that party bears risk, the amount of damages shall be reduced to the extent that these factors have contributed to that loss, having regard to the conduct of each parties. So that would be relevant to the application of Article 122. And unless I can assist any further, I appreciate I've gone over a little bit there. But unless there's any further questions in relation to any of the contractor's grounds.
Are you going to put that article in the bundle?
Subject to, yes, it's subject to.
I think you should.
Okay.
You should put in the bundle.
I can ask my solicitors to add it to the bundle.
Yeah. Mr. Mott, any question from the judges or to Mr. Bura? No? Mr. Mott, is 7:15 according to my time, which is 11:15 your time. We have agreed to break at 11:30 your time. Do you want to start for 15 minutes now and break again, or what?
I'm entirely in your hands, my lord. I will need some time to respond to my learned friend, and I don't want to cause inconvenience to anyone by yet sitting yet later or running into tomorrow. So I'm very happy to make a start for 15 minutes before we break, unless that would be.
Yeah, I'm most grateful to you. Thank you very much, Mr. Moore.
Thank you, my lord. Thank you to my learned friend for his very helpful submissions. I should say I'm not massively familiar with case lines, but I will do my best to deploy it. If I can just summarise, as we understand it, the contractor's appeal concerns essentially 3 topics in relation to its delay claims. The 3 topics being: 1, the proper construction of clause 20.1, And that gives rise to ground 1, which is whether the last paragraph is a condition precedent, and ground 4, which is when does the timetable start running under clause 20.1. So that's the first topic. The second topic is grounds 2 and 3, which is whether the notice of dissatisfaction requirement offends against DIFC law and how it should be construed. That's amended clause 3.5. Sorry, my lord.
I think ground 3 was not pursued because it doesn't arise if the other points.
Quite so, my lord. I just put the yes. It's ground 2 and what was also ground 3, but quite so, my lord. So ground 2 we need consider only. And then the third topic is the application of the so-called prevention principle and its interrelationship with the duty of good faith, covered by grounds 5 and 6. I just want to make some introductory comments about delay claims. The first point to note is my learned friend repeatedly asserted how his client was liable for all of the liquidated damages, but only some of the delay on the learned judge's analysis of causes of delay, leaving aside conditions precedent and so on. Under this contract, like every similar contract in at least my experience, and I'm sure my learned friends, under this contract, liquidated damages are capped. In other words, the employer's right of recovery against the contractor is very significantly restricted to a very modest proportion of the employer's potential losses. It's fixed at 10%, which is conventional, 10% of the contract sum, sorry. Doesn't bear any relation to what the employer's total exposure in the event of delay. And in this case, there's 320 something days of delay, and the liquidated damages equates to about 99 days of delay. So in other words, on any construction of this contract, if the contractor is significantly late, perhaps as sometimes happens years late, all of that loss is suffered by the employer with no remedy whatsoever. And that's indicative of two very important points. The first one, which is so obvious to us, was wholly overlooked by my learned friend. This is a commercial deal between two sophisticated, legally advised commercial entities. Secondly, arising from that first point, the terms of that deal must take precedence over wider interests of fairness, or what would be a fair outcome. Well, learned friend's entire submission is to the effect that his client has been terribly unfairly treated for lack of putting in notice, for failing to comply with the terms of the contract dealing with how claims are to be made. But it was in the context of a very straightforward and conventional commercial deal where risk was allocated, where the contractor took on a very modest part of the risk of delay, the employer took on a much greater risk. The second point, broad point I want to make is about, throughout my learned friend submissions, particularly in relation to the so-called prevention principle, and in the commentaries, there's repeated reference to the employer being in breach of contract. The implication is that the employer is some sort of terrible person who possibly deliberately or for lack of care causes the contractor immense hardship and then greedily scoops up this windfall, as my learned friend put it. The reality is that with every project of this kind, the employer itself is an incorporated institution with backers, acting, so far as the project is concerned, through external professional consultants, an engineer, project manager, and the like. And the reality is that when there's delay on the project, of course, sometimes it's caused by the employer, when an employer suddenly decides to put a swimming pool on the 30th floor or whatever. But much more likely, in my learned friend's experience and mine, I'm sure, much more likely is the failings are not failings of the employer as such. They are failings of professional parties that the employer is contractually responsible for. In other words, the external professional team. Now, the contractor says, well, I don't care. I don't care whether it's the engineer or the employer. It is that these are all employers' people under the contract. But that's right. But when we come to then look at how these clauses are working, the employer's position is if there's a delay on the project, it's not going to be my fault, as in me, Employer Inc. or PANTHER as we're called in this case. It's going to be either the contractor failing to progress the work, or the design team, the professional team who are giving instructions, who are dealing with problems as they're encountered, are trying to coordinate the different designs, perhaps dealing with enabling works contractors or other parties. And the employer's position is, well, if there's a delay, I'm going to want to make claims either against the contractor, albeit subject to this extremely low limit of what delay damages they can recover, or against my professional team, or if not make claims against the professional team, I'm going to want to be able to put pressure on the professional team to avoid delay. Now, of course, it's only right, or it's only standard, that under the building contract itself, failings on the part of the professional team are deemed to be the employer's responsibility rather than the contractor's, or rather than neutral. But in terms of the overall fairness or the purpose of all of this, the employer wants a situation where whoever's responsible for the delay, they're going to be able to recover that cost, or best of all, mitigate it. I think the third point to make is just in terms of the general provenance of these clauses. Clauses 20.1 and clause 3.5 are standard provisions. Now, it is important to know that the provision that we're concerned with in 3.5 is amended. And that's obviously significant because one needs to look at, well, what did the parties do to the unamended clause? So if we concentrate on clause 20.1, this is an unamended standard provision appearing in the most popular form of contract used across the globe in an international context. I just want to very briefly address the history of this form, but we would say, well, of course, one looks at Chod and Churton and other Dickensian cases to see the development of the English law and to understand how these cases have come about. But the commercial environment in which this FIDIC 1999 form is used bears absolutely no relation to the sorts of problems that the Victorians were considering. That doesn't change the fundamental rule of construction that a party is very unlikely to agree to be liable for the other party's breaches. Nonetheless, it is wholly relevant that this is an absolutely standard clause. Now, I just wanted to very briefly go through the background to FIDIC, because I'm sure the court is well aware. But basically, FIDIC started producing standard forms in the 50s. The FIDIC itself goes back a century or so, but it started producing standard forms in the 50s. And then it started aping the English ICE form with the third edition, which is in, I think, the 1970s. So the FIDIC is an English language, English culture, English legal culture form of contract, very closely modelled on the English ICE form. You then have the fourth edition in 1991, which was in play when I started practicing in construction law. And the fourth edition used words provided that. So it didn't have the terms that we're looking at now. It said that provided that the contractor has given notice within 28 days, then the engineer will determine whether an extension of time or may determine. And that wording was definitely open for argument as to whether that was a condition precedent. The words provided that the contractor has put in a notice, it looks like a condition precedent, but it wasn't quite as emphatic. And what happened in 1999 is, presumably because this is what the industry wanted, or the World Bank, or whoever it was that was driving reform, that FIDIC decided in 1999, in the form now being used in this case, that the provisions needed to be tightened up. It needed to be spelt out beyond all possible argument, and the reference to prevention and the reference to time will not be extended, that the contractor will not have a claim. These were added in the 1999 edition of the contract, so that there could no longer be any question whatsoever. If the contractor doesn't comply with the notice requirements, it will lose its entitlement to more time. In other words, it will be liable to the employer for delays, even when those delays have been caused by the employer. So that's what happened in 1999. And of course, we have a subsequent edition of FIDIC in 2017, which is even more complicated, even more notices, even more deeming provisions. We haven't got it in evidence. I don't think, I've never come across it in practice. It's obviously a hateful document that nobody likes, but the FIDIC 2017 edition does more to spell out yet further changes, so that the engineer has to say if the relevant notice hasn't been given, and if he doesn't, the engineer, the parties are bound by that, and so on and so on. The point is that these
objective, I suppose, is just to get the project completed as ASAP. You know,
my lord, I think the objective of this clause 20.1, it serves numerous objectives. One is to enable the employer to mitigate and avoid delay as they occur, to bring claims against other parties who are responsible for the employer to say to the engineer, look, the contractor is telling me he hasn't got this information, you need to sort yourself out. Thirdly, what is very clear is that parties don't like spending money on arbitrations. They don't want to have an arbitration going on 5 years after the project finished. I'm happy for them to do so, but they don't like this, and they want to avoid that outcome. And the perception, rightly or wrongly, in the drafting world is, if claims have to be notified at the time, or they are lost forever, that is how you get them resolved at the time, and you don't have the situation where parties are picking over requests for information, technical queries, and drawing issues.
Lawyers do that, not technical people. Lawyers are doing that to find faults on the other side.
At vast cost. And the perception is, no, it would be better if claims have to be notified contemporaneously, so that there is a record of what the claims are, a limit to what the claims are, and ideally they are resolved at the time. And that is the direction of travel. And the reason for going through the brief history of FIDIC is this is a new thing, and it puts in context some of the very old cases that my learned friend relies upon. I don't criticize them for relying on them, but they need to be, a different culture applies now. And the movement of FIDIC is towards more and more of these notice requirements with significant consequences. And all of that needs to be understood when we then come to look at this. Now, before we close for prayer, I just want to make a final point, that obviously this seems to be such a straightforward and obvious point, but obviously where one has a notice regime, a claims regime requiring notices and so on, it follows that highly meritorious claims for substantial sums of money will be lost. That is the nature of such a regime, and all the tribunal should be doing is looking at the contract terms to see, well, are they clear enough in having that effect? And FIDIC, they couldn't really do much more. It actually said there will be no extension time, there will be no claim. It is impossible to see how they could draft this more clearly to have these effects. My lord, it's now 11:28 in the UK, something like 7:28 in Malaysia, and I think 3:28 in Gulf.
Okay, so we'll take a 30-minute break. We'll come back
30-minute break
at 12 noon for you, and 4 p.m. for Judge Ali and Shahila.
8 p.m. for yourself.
8 p.m. for myself.
Thank you, my lord.
So I'm not going to leave this channel. I'm just going to turn off my video and sound. I mute my microphone, and I've turned off the video because I don't want to have the problem of coming to reconnect. It's so difficult. Okay. Thank you very much, everybody.
Thank you.
I managed to grab a light dinner as well. I hope you had some light lunch or brunch or something like that within the last half an hour.
Yeah, everything.
Good for you. Privilege of hearing online is I can have coffee.
My lord, if I may proceed, I think the time now is.
Wait, Mr.
I'm so sorry.
Justice. Yeah, Lord Glennie is here. Okay, then sorry.
Yeah, I'm here.
My picture is all overlapping on yours. I don't know how to move it. How to rearrange it. Emma, just go on, please. Thank you.
My lord, I understand it's 12 in London, 4 p.m. in Dubai, and 8 p.m. in Malaysia,
Yes.
is my understanding. And I'm going to speak
Yes,
for
yes,
an hour an hour and a quarter to respond to my learned friend's appeal. Just as a preliminary point, there was a request earlier for a sort of simple flowchart showing how the various appeals would impact on the delay claims. Our understanding is that there is no discrete claim made against grounds 1 and 2, that they are just necessary because if the contractor succeeds with ground 4, which is the main appeal, they also need to succeed with those other 2 grounds in order to get anything at all. And there is no analysis of what would happen if they succeeded just with ground 1 or just with ground 2, because by implication they would in effect get nothing at all. Or if something different is said, we have no notice of it at all. My lord, I should also mention that you will appreciate, or you may appreciate, that the employer's ground 1 is in relation to the expert evidence, and if there is to be some factual inquiry, which we would strongly urge against, then that would obviously bring into play our own ground 1, but not otherwise. My lord, if I can quickly then turn to the first part of the contractor's appeal, which is covered by grounds 1 to 4. Ground 1 is relatively straightforward and is concerned with clause 20.1. Well, I'm going to try and, for the first time, direct the tribunal to look at clause 20.1, which is at C75, but it's necessary to scroll down. Sorry. Claims, disputes and arbitration. Ground 1 is concerned with the text that I hope is on the screen now. Within 42 days after the contractor became aware or should have become aware of the event or circumstance giving rise to the claim, or within such other period as may be proposed, the contractor will send to engineer a fully detailed claim. And the question is whether, as the judge found, that requirement is also a condition precedent. And without spending time on it, I refer the court to the learned judge's analysis at paragraphs 44 to 46 of his judgment, which are at B61. And the contractor contends that it isn't expressed as a condition precedent, and it's to be contrasted with the wording in the second paragraph, which governs the initial notice, the requirement to give notice within 28 days, where FIDIC have spelt out that if there is no such notice, the contractor shall not be entitled to additional payment, and the employer shall be discharged from all liability. But my lord, this is a point of no doubt great interest to FIDIC users. However, it has no effect whatsoever on the outcome of this case, save that the contractor would have grave difficulties if it succeeded with its other grounds, but not this one. My lord, I would say that I haven't found support for the judge's approach, nor is it's fair to say have I found in my research anything strongly expressing the contrary view. It is fair to observe, in the interest of assisting the court, that these provisions at the last paragraph are sometimes amended by parties to spell out that this requirement is also a condition precedent. Where that takes one, I suspect, is absolutely nowhere whatsoever. But my lord, I don't propose to spend longer on ground 1. The short point is it isn't in fact going to make any difference to the outcome of this appeal. So I will, if I may, move swiftly on to ground 2, which is concerned with amended clause 3.5. And 3.5 in its original form So it's at page C28, this being the FIDIC conditions of contract. So the original clause 3.5 provides for determination by the engineer. And the second paragraph in the original says the engineer shall give notice to both parties of each agreement or determination with supporting particulars. And the original draft, this is the part that's amended, there's a second sentence of the second paragraph. The original deleted text is each party shall give effect to each agreement or determination unless and until revised. And that's to be contrasted with what the parties have specifically agreed, which is at C144, delete the second sentence of the second paragraph, the text I just read, and replaced with each party shall give effect to each agreement or determination unless one party notifies the other of its dissatisfaction with the determination within 14 days of receiving it. Either party may then refer the dispute to be settled in accordance with clause 20. And we say, we say that, as the judge found, that is an agreement not to seek to disturb the engineer's finding unless notice of dissatisfaction has been given, and that analysis itself is not challenged. The contractor's appeal is whether this offends against Article 123 in terms of reducing a limitation period. I would point out that amended clause 3.5, although it is a bespoke amendment, it is of a very standard type, that it is conventional to require parties to give a notice of dissatisfaction within a relatively short period if they want to take a dispute to the next tier. And there's obvious common sense if the party's aim is to resolve disputes contemporaneously and to avoid the nightmare cost of arbitration or litigation continuing years after the project is finished. I would also observe that obviously each party is subject to clause 3.5. I think my learned friend put forward the argument that, well, these provisions should all be construed favourably to the contractor. There's absolutely no basis for construing 3.5 in favour of one party or the other, given that it applies with equal force to each of the parties, because its purpose is simply to avoid long-running disputes unless parties feel strongly enough about them. So it doesn't fall to be construed particularly favourably one way or the other. In terms of this provision, I would just draw for completeness, I would just draw the court's attention to the original terms of the FIDIC contract at C76. So C76 is part of clause 20. What we're looking at is the end of clause 20.1. Clause 20. I'm so sorry, I meant C78. If we could just go to C78 is still part of clause 20, which deals with disputes and dispute resolution. So this is in the standard FIDIC form, which the parties adopted as part, wasn't amended. And here we have an equivalent provision that if parties were dissatisfied with the DAB's decision, Dispute Adjudication Board's decision, then they were required to give notice of dissatisfaction or be bound by it. And then the FIDIC form in its original state provides for a tiered dispute resolution process, but with the proviso that if you don't serve a notice of dissatisfaction, or NOD as it's now called in the present FIDIC form, then you lose the right to refer disputes to the next tier. And we say, well, that's not only is that conventional, it would be odd if there weren't such provisions in a modern contract of this kind, albeit this particular proviso at page C144, amended 3.5, it is itself a bespoke amendment, but the concept of the parties agreeing to be bound unless they serve a notice it is an entirely conventional and, dare I say it, sensible one if the objective is to avoid long-running disputes hanging over the parties with uncertainty as to the end cost and obviously the certainty of spending a lot of money on lawyers. But if I can turn now very briefly to my learned friend's grounds of appeal, his objection is that this offends against Article 123, and if I may just bring that up, it's at page E614. Limitation, Article 123 provides limitation. An action for breach of any contract must be commenced within 6 years after the cause of action has accrued. It's an exception for fraud. By the original agreement, the parties may reduce the period of limitation to not less than 1 year, but may not extend it. And we say that that's an entirely straightforward provision. The totality of my learned friend's point is amended 3.5 also imposes a time limit for dispute resolution, and therefore it's caught by this. But that doesn't go anywhere. That Article 123 is referring to a specific, it's making a specific provision that after accrual of a cause of action for breach of contract, proceedings must be commenced within 6 years or by agreement a shorter period, but not less than 1 year. That has absolutely nothing to do with the requirement to serve a notice of dissatisfaction. The reference in Article 1231 to the requirement that an action be commenced is clearly a reference to litigation or equivalent process being commenced. In other words, a party going to the court via their solicitors and issuing a claim form. That has nothing to do with clause 3.5, which simply provides that the parties agree to be bound by the engineer's decision unless they serve a notice of dissatisfaction. And as we've seen, requirement for notice of dissatisfaction appears elsewhere in the FIDIC form, and again is an entirely standard provision. And it would be very odd if the DIFC law made such a commonplace and ordinary and inoffensive provision ineffective. I would make a further point is that obviously the parties could have agreed simply that the engineer's determination or some other contractual mechanism was immediately finally binding. So the parties could have had an agreement that, for example, once the engineer serves a notice of his or her decision, that's immediately binding on the parties, or they could have agreed a number of other provisions, as one sees in different jurisdictions, where service of a notice has, or a document or a decision has an immediately binding effect. Now that would be effective. As far as I'm aware, my learned friend wouldn't seek to suggest that, for example, an agreement that the engineer's decision was in all cases immediately binding. He wouldn't suggest that was somehow ineffective. But why shouldn't the parties agree that the engineer's decision be finally binding if that's what they feel suits their joint commercial, their common commercial interest? But instead, what the parties have agreed is just simply a very minor modification to such an arrangement. They've agreed that it is binding, unless one or other party states that they're not happy with it. And what my learned friend seeks to argue is, well, that somehow then makes such an arrangement ineffective. But in circumstances where an agreement that the engineer's decision was immediately binding would be effective. And that is fallacious. That doesn't make any sense. Agreeing that an engineer's decision be binding, or agreeing that an engineer's decision be binding unless a notice is served within a short period of time, has nothing to do with limitation. What it's to do with is agreeing by consent that an engineer's decision will have a certain effect for the purpose of resolving or avoiding disputes, which is obviously commercially highly advantageous to the parties. And as to remind everyone, this is a provision that the parties specifically agreed. It's a bespoke amendment. It won't have taken anyone by surprise. Instead of agreeing that the engineer's decision is immediately binding, the parties have agreed that there will be a short period of reflection of 2 weeks so the parties can decide whether they are going to take it any further or not. And that has nothing to do with limitation. That we're right, my lord, is apparent when one considers, well, what is the limitation period for a breach of contract claim in this case. I'll give an example. Suppose that the employer is in breach of contract. For example, the employer is late providing some information that the contractor needed, or the employer is late providing possession, and that breach occurs at the beginning of year one of the project. But for one reason or another, the issue is not considered by the engineer until sometime later, as is often the case, say year three. So some years have gone by. The engineer then decides that the contractor was not affected, or that there was no breach, or whatever the engineer's determination is. And at that point, the parties have 2 weeks to indicate whether they're dissatisfied with the engineer's notice. The limitation period, for the purpose of my hypothetical example, is and remains the statutory one of 6 years. If the contractor then brought a claim, it would not be open to the it would not be open to the employer to say, well, your claim is time barred because you didn't bring it within 2 weeks of accrual of the cause of action. Accrual of the cause of action in my example is at the start of year one. The limitation period is the statutory one of 6 years. And again, we say this example illustrates the straightforward point that notice of dissatisfaction, so as to prevent the engineer's determination of the claim becoming finally binding, has nothing to do with limitations. It has a time element, as do a lot of provisions in the contract, but that's it. I think a secondary point we've made in written submission is that obviously a challenge to the engineer's decision is not itself a claim for breach of contract. So in my example, if the contractor had a claim for breach of contract, going back to, let us say, the very beginning of the project, that is the cause of action for the purpose of Article 1231. The limitation period for that cause of action is 6 years, that there being no agreement for some shorter period. A challenge to the engineer's decision is not a cause of action. Moreover, serving a notice of dissatisfaction is not commencing an action for breach of contract. A claim for extension of time is not a claim for breach of contract at all, not within the meaning of Article 1231. Where a contract provides for extension of time, that's a contractual mechanism dealing with a set of facts, a set of circumstances identified in the contract. It's not a contractual remedy. It doesn't accrue in the way that a cause of action does. So when one looks at the main substance of the contractor's claim is it seeks to avoid paying liquidated damages of some 4 million dirham. That's not a claim for breach of contract as such. Their complaint is that they should have been granted an adjustment to the time for completion pursuant to clause 8.4 and clause 20.1. That last point is further illustrated by the fact that included within the contractor's claim are claims for things found in the ground, which obviously nothing to do with the employer in terms of breach of contract. My client didn't warrant that there would be nothing unhelpful in the ground. It nonetheless gives rise to, on the contractor's case, to an entitlement to more time. But again, that's not a claim for breach of contract. So, my lord, in summary, we say Article 123 is concerned with the commencement of court proceedings in arbitration, should one have a contract subject to arbitration, but also subject to DIFC law. It has absolutely nothing to do with a sensible agreement, such as in this case, that disputes be decided by the engineer in the first instance, and that such decision be binding on the parties unless a notice of dissatisfaction is served. So, my lord, those are grounds 1 and 2, which we say are something of a sideshow and get the contractor absolutely nowhere. We now come to the main event, which is ground 4. I'm so sorry.
Can I just ask you a point I put to your opponent, Mr. Burrell? The construction on one view, leave aside what is that it's a bespoke amendment. But the construction on one view of the second paragraph of 3.5 could be, I suggest, that you have to give, that if you don't give notice in 14 days of your dissatisfaction, then you just have to get on with it and carry on with the contract. But it doesn't stop you raising a point at the end of the end of the project. Now, I know your primary case, or one of your cases, is, well, it's a bespoke change to the standard form, which expressly provided that. But leave that point aside. On the wording, do you accept that sort of possible interpretation?
Well, Lord, I'm just going to put it back on the screen. Thank you for the. So it's on page C144. Well, we would suggest that the judge's reading was the correct one. The word "then" in the last sentence of the amended text, the additional text, in either party may then refer the dispute to be settled in accordance with clause 20. Having regard to the way the paragraph is put together, but also the purpose of a notice of dissatisfaction, we would suggest by far the most obvious, if not the only reading, is once a party has given notice of dissatisfaction, you may then, but not otherwise, refer the dispute in accordance with clause 20. It's difficult to see what other meaning could attach to then. Perhaps more importantly, it's difficult to see what would be the purpose of a notice of dissatisfaction with that time limit, unless it was to ensure, precisely as we see with the other provisions in clause 20 and one sees in other forms of contract, what is the purpose of all of this, unless it's to ensure that the circumstances in which the engineer's decision can be disputed are limited to those cases where a party is given such a notice. It would deprive. So it's two reasons for supporting our interpretation, my lord. I know your question was, would it be possible to read it in a different way, which I'm not addressing directly, but we rely on our reading for firstly because that's the purpose of a notice of dissatisfaction, is to preserve a dispute despite it having been decided. And that would make sense that if you don't serve the notice, it has that effect, that it isn't preserved. And secondly, the word "then" in "may then refer" is, we say, clearly intended to follow on from having served the notice. So to answer my lord's question, well, could it be construed as meaning simply that you comply with the decision, and even if you've not served a notice of dissatisfaction, you're still entitled to refer the dispute at the end? We say that with respect that would be a strained reading of the clause that would make the notice of dissatisfaction completely pointless, and it would be a very curious amendment for the parties to have agreed.
Well, the notice on that view, just sorry, I don't want to prolong the discussion, but on one view, the notice of dissatisfaction within 14 days means you actually then have to address the point before you need to get on with the contract, say a variation or something. There may be a dispute about whether something is a variation, whether it's a legitimate variation, and so on. Engineer says it's a valid instruction, variation order, or whatever. The party that doesn't like that decision has a choice. He can either just get on with the contract and say to himself, well, I'll deal with that at the end in final account, or he can he can argue about it there and then, in which case he's got to trigger the argument within 14 days. And it provides a very brief timescale within which these things have to be resolved without holding up the whole project.
Well, with respect, the only brief timetable on the if we're looking at page C144, the only brief timetable is serving the notice of dissatisfaction. There's nothing to say that having served that notice, that then this whole the clause 20 process will then take effect within the currency of the project. So the engineers made a ruling which, in practical terms, what the engineer will be deciding is whether additional money is to be paid. So if, for example, there's an instruction to carry out work and the contractor contends it's a variation and the employer contends it's within scope, the contractor has to comply with that instruction. The issue is, do they also get paid more money, which itself obviously doesn't hold up the project. But if the on my lord's proposed possible interpretation, if the requirement is that the parties quickly resolve the dispute in circumstances where they're dissatisfied with the engineer's decision, but that's not supported by the wording, because the only short timetable is serving a notice of dissatisfaction, not, and then they must refer it within 14. They must refer it under clause 20 within 14 days. And the reality is that clause 20, which ends with court proceedings, it is not going to be concluded within any short timetable. There's no possibility of the parties, as this case demonstrates, no doubt, there's no possibility of the parties getting to a final decision by the clause 20 process within the currency of the project. So we say, my lord, the only bit with a short timetable attached to it is giving notice that you're unhappy with what the engineers decided, which will then entitle you to go down the clause, the various tiers of clause 20, ending ultimately with litigation, but in practice over a relatively drawn out period. And so we say that the reference to 14 days supports our reading. It's not saying so that this dispute can be resolved very quickly, because that there's just no mechanism in clause 20 that would allow that. The 14 days is saying within a relatively short period of time, you need to tell everyone that you're going to be taking this further, and that's all that could really be expected of the parties.
I follow. Thank you.
Thank you, my lord. So I think that's all I was going to say on ground 2. We then come to ground 4, and under ground 4, my learned friend's argument is that the 28-day period. Just put clause 20 is on page C75, and I will just return to that. So on page C75, so ground 4 of my learned friend's appeal for the contractor is that when reading the second paragraph, which contains the condition precedent, that the complaint is that the 28-day period starts later than the judge found. The wording of clause 20.1, the material bit, is at the end of the first paragraph. The 28-day notice, the notice should be given as soon as practicable and not later than 28 days after the contractor became aware or should have become aware of the event or circumstance. That's the event or circumstance giving rise to the claim. And we say, well, that's fairly straightforward. One can think of a number of obvious examples. If there's a delay in receiving information or an instruction to carry out more work, or the discovery of adverse ground conditions, those are the events or circumstances that give rise to the claim, and it's subjective awareness or deemed awareness of those events that trigger the timetable, and it could not be simpler than that. Now, in order to succeed with the contractor's appeal, it needs to address 2 points. The first is it needs to successfully persuade this court that the calculation of the 28 days starts later to the time that the court of first instance adopted. That's point 1, which is what ground 4 is about. But in addition, as we've argued strongly, the contractor must also show that there are a load of delay events which, were the time calculated later, would suddenly come into play in circumstances where they weren't otherwise. In other words, that if one had a later start date for the 28 days, notified delay events would be part of the analysis that otherwise are rejected. Now, just to be absolutely clear, the appeal is limited to, so in terms of challenge to the learned judge's decision, the grounds of appeal are limited to challenging when the 28 days starts, and not when the notices were given and so on. Now, I'll come back to that in a moment. My lords, we oppose the appeal by reference to 3 reasons, which I'll just summarise. One, we say that the TCC authority of Obriscon and Attorney General of Gibraltar, decided by Mr. Justice Aikenhead, does not support the approach that the contractor urges. Secondly, we say if it does, it's wrong and the court should disregard it. And the learned judge's reading of clause 20.1 as presently on the screen was correct. And then the third reason is that even if the contractor were wholly successful and some later point in time should be adopted, in other words, when the delay starts, that makes no difference whatsoever on the facts of the case, given that no facts are challenged. So the court is bound by the factual findings of the court at first instance. So if I can now briefly address those 3 points, my first being that the decision of Mr. Justice Aikenhead in Obriscon does not support the argument that the contractor puts forward. So our argument is, well, you look at clause 20.1, and it is expressed in, we would say, very clear and emphatic terms. The event causing delay, or the event causing entitlement to additional payment, or the event giving rise to the claim occurs, and if assuming the contractor is aware of it, they give notice within 28 days, or if they weren't aware of it but should have been, within 28 days of that. Now, my lord, if we can turn to the judgment, since that quotes from Mr. Justice Aikenhead's decision, the relevant passage in the judgment, I'm on page B63. And at B63 of the judgment, paragraph 51 of the judgment of Sir Richard Field, at paragraph 51, the learned trial judge sets out the relevant text from Obriscon. So Obriscon's a first instance decision in 2014. It's a very lengthy judgment, but the treatment of this clause is is relatively brief and is set out, I think, in its entirety at paragraph 51, as shown on the page at B63. Now, as discussed, the purpose of clause 20.1, it serves a number of purposes. It's to ensure that delay can be mitigated, that the employer can put pressure on others that are responsible for the delay. It's to avoid very stale claims being made at a later stage. It's to ensure that when the dispute resolution process takes place, the parties have a clear and finite agenda of what items are in play and what items are not. And it's in that context that Mr. Justice Aikenhead's analysis should be considered. Now, Mr. Justice Aikenhead refers to clause 20.1 and also clause 8.4. But if we just look at the example which my learned friend took the court to, in his example, so he considers the text of 20.1 and the interplay with 8.4. In his example, he says, the entitlement to extension thus arises if and to the extent that the completion is or will be delayed by various events. This suggests extension of time can be claimed, either when it's clear that there will be a delay or when the delay has been at least started to be incurred. Now, where my learned friend goes with that is, well, so they can wait until the delay starts before they serve their notice. They don't have to serve notice when the event or circumstance giving rise to the entitlement occurs. If one then looks at the example that Mr. Justice Aikenhead gives, there's a hypothetical example might be helpful. A variation is issued in June. At the time of the instruction, that part of the carriageway is not on the critical path. So what he's suggesting is that there is no claim for an extension of time. No claim has arisen because at the time of the instruction, which is going to be the event giving rise to the claim in due course, it's not impacting the time, the critical path. So it's not giving rise to a claim. And he then says, although it's foreseeable the variation will extend the period for constructing the dual carriageway, it's not foreseeable that it will delay the work. But by the time the dual carriageway is started in October, it is only then clear that the works overall will be delayed by the variation. It's only, however, in November that can be said that the works are actually delayed. Notice does not have to be given for the purpose of subclause 20.1 until there is actually is delay, although the contractor can give notice with impunity when it reasonably believes that it will be delayed. The event or circumstance described can mean either the incident or the delay which results, or will inevitably result from the incident in question. Now, my lord, in that example, of course, if the contractor has no reason to make a claim, because it doesn't at that stage appreciate that the relevant event is going to cause a critical delay, nobody could suggest that the 28 days starts running at that time. But we say, well, that's that analysis is in terms of giving the contractor the benefit where it doesn't have reason to think it has a claim. Well, that is fair enough, but doesn't come anywhere near supporting my learned friend's analysis, which is based on by reference to when the delay events finish, which has nothing to do with the approach taken by Mr. Justice Aikenhead.
If one goes back to the clause itself, 20.1, which is at somewhere
C75.
C75. Surely the starting point is that the contractor must consider himself to be entitled to an extension of time. And you're not entitled to an extension of time until there is some delay.
Yes, but I understand that point, my lord, but well, there's 2 points to make. He becomes entitled to an extension of time when there will be delay. That's the learned judge's conclusion, and it's obviously right.
Why is it right?
Sorry, my lord.
Why is that obviously right? You're only entitled to an extension of time when you start encountering delay, don't you?
If I just take my lord to C44. So C44 is still in the FIDIC terms of contract. Sorry. So C44 is clause 8.4.
All right, hang on a second. Yeah.
So this is precisely the point, my lord, that the learned judge, the trial judge, the approach he took. The contractor shall be entitled, is subject to clause 20.1, to an extension of time, if and to the extent that the completion is or will be delayed. So to answer my lord's question, the contractor has an entitlement once it becomes apparent that there will be delay. And if one thinks about it, that's obviously the more useful operation of these arrangements. If, for example, the employer issues an instruction, the engineer on the employer's behalf issues an instruction requiring the contractor to do additional work, which is going to affect the contractor's critical path, that is the delay or circumstance giving rise to this claim under 8.4. And the employer at that stage is entitled to notice from the contractor, because as the authorities point out, well, it's obviously the contractor who knows where their critical path is, whether they can mitigate delay, and what significance the instruction will have. The employer is ignorant of all of that. And in principle, the idea is that, well, if the contractor comes back to the employer and says, well, that's going to cause us a delay, then the employer can have a rethink. So, it is an absolutely vital point, and I'm grateful you asked me. So we were looking at 20.1 in terms of extension of time.
But we have to put ourselves in the position of the contractor. You know, we are lawyers sitting up here, the contractor sitting down there looking at the project. And as a contractor, I think he will want to notify the employer the moment he knows that it's going to be critical. You know, it's going to be delay. You asked me to do this even today. The 28 days not started yet. Is still the project is not completed yet. But I foresee that this is going to be a delay if you give me something, or maybe something doesn't require a delay. It will not cause a delay. But in many circumstances, it will cause a delay. For example, so
Yes.
he should be able to decide any time. It doesn't have to be just after when the critical situation commences, or you know. So to me, I don't know. I'm just thinking now. I'm putting myself in the position of a contractor and see how the contract, because FIDIC is drafted by contractors, not by lawyers.
Yes, my lord.
Technical contract, isn't
By
it? Don't you
engineers
agree with me, Mr. Mott?
Yes, of
Don't you
course, my
agree
lord.
So you
I
have
don't
to
know.
put yourself in the position of a contractor, not a judge sitting in the Eiffel Tower, in the whatever tower, and making decisions for the engineer. You have to put yourself in the position of the engineer. How would they feel? How would they, you know, the situation arises?
But my lord, if we can just go back to C75. So C75 is clause 20.1. And the point I was making is the trigger for the 28 days is the event or circumstance giving rise to the claim, either knowing of it or deemed to know of it, should have been aware of it. And my lord Glennie made the point that, well, for extension of time, entitlement must arise when there's delay rather than the instruction itself. And
I was overlooking 8.4.
I was just recapping as to where we got to, my lord. So I'm grateful. But so we say 8.4 answers that point by entitling the contractor to prospective extension of time. And I make the point that, well, obviously that makes a lot of sense for all the parties, because if it serves any purpose at all, these notice requirements ideally are avoiding or mitigating delay and or alerting the parties to the consequences of additional work or late information. So we say, well, once it becomes apparent that there's going to be a delay, or that there's going to be an entitlement, there is an entitlement, then that's the trigger. And the entitlement doesn't need to be for anything significant. It's the wording of 20.1 is, if the contractor considers itself entitled to an extension of time and or additional payment, then the obligation to give notice arises. So if a delay, even if the delay isn't critical to the works as a whole, but will cause some local additional prelims or some additional cost, then that would trigger an entitlement, even if in due course the claim appears to be much more significant. Now, my lord, what I wanted to...
Sorry,
I'm so sorry.
You mentioned Article 8.5 or 85 just now. I just want to know,
it's
what
8.4.
The term entitled there, entitled. When is the contractor entitled to an extension?
So this
was it that 8.5 that you pointed
Yes, my
earlier?
lord. 8.4 deals with extension of time. It's at page C44.
8.4 shall be okay. Well, yeah, okay. That's
The contractor shall be entitled subject to subclause 20.1. So note that clause 8.4 is subject to the notice requirements, not the other way around, although obviously it's legitimate to look at 8.4.
Yes. Subject to 20.1. Subject to. So what else is the situation where the contract is entitled under 20.1? The
entitlement to time is under... Sorry, my lord.
The condition cited 8.4 is not included in 20.1. It's not intended to be included in 20.1. So the situation in 20.1 is a different set of circumstances altogether.
My lord, this is my understanding of the FIDIC form of contract. there are various provisions in the form dealing with payment, additional payment, adjustment to the time for completion or extension of time. They are scattered. They're not just in 8.4. They are scattered about the contract.
Those are entitlement. You're saying.
Those are dealing with entitlements. 20.1, all of those entitlements or claims are subject to the successful operation of clause 20.1, which deals with notices of claims and the escalation of disputes in the rest of 20.
I understand.
And so 8.4 is not the only case where the contractor has such an entitlement, but it is obviously relevant when one is considering entitlement to extension of time. And the short point, which I make now for the once again at the risk of repetition, is that the contractor's entitlement under 8.4 is not limited to there being delay, but that also where there will be delay. And Mr. Justice Aikenhead's argument is, well, it doesn't say is or will be delayed, whichever is the earlier. However, when one looks at clause 20.1 at C75, it's clear that it is once the event occurs or the contractor becomes aware of it, the entitlement, then the time starts running. So it doesn't need to say whichever is the earlier, because that's covered in clause 20.1. And as I just mentioned, clause 8.4, that entitlement to extension time, is subject to clause 20.1. And what I was trying to get at was the learned judge's observations. Now they're at B64, and if we can, the learned judge deals with all of this in his judgment, the judgment that's subject to this appeal. So I'm now on B64, which is the judgment, and paragraph 53, the learned judge says, if Mr. Justice Aikenhead was intending to say in Obriscon that if a contractor were aware of an event or circumstance that gave rise to the real prospect of a delay on the critical path, he need not seek an extension of time giving notice of that event or circumstance under subclause 20.1 until 28 days had elapsed from the inception of the critical delay, which is how the contractor construes the judge's words. I respectfully disagree with what the judge said. In my opinion, the effect of the first paragraph of subclause 20.1 is that if a contractor is aware or ought to have been aware of an event or circumstance that could give rise to an EOT claim, he must give notice of that event or circumstance within 28 days. And we said, well, obviously that makes sense. The contractor can't wait to the end of the project to see what delays have occurred. The idea is to give notice when it is apparent that the contractor has an entitlement. And that's the approach that the judge took.
The only question I have is on that passage you just read. In the last sentence of paragraph 53, he says, in my opinion, effect of the subclause 20.1 is that if a contractor is aware or ought to have been aware of an event or circumstance that could give rise to an EOT claim, wouldn't it be more accurate to say that is likely to give rise?
Yes, my lord, I understand. It's not intended to be every conceivable possible. Absolutely, my lord. It's the test in 20 is reasonably clear from 20.1.
And the other one is, if you read the 21, there's a word there to say that if it is not done within the 28 days, the 28 days. So how did Aikenhead goes and interpret that as after 28 days or within?
My lord,
he says that it's not done within 28 days. Where is that?
My lord, my understanding, and obviously I have immense respect for Mr. Justice Aikenhead, but my understanding that we say the error that he made, if he made an error, was he's not suggesting any deviation from the 28-day requirement, but he's suggesting that the contractor can choose whether to use the event or circumstance that causes the delay as the trigger, or the delay itself. And he gets there by pointing out that 8.4 refers to if the contractor is delayed or will be delayed. And he says, well, that gives the contractor the right to make a claim when he is delayed or when he will be delayed. And we say, no, that's the risk of using a cliche, that's the tail wagging the dog. Clause 8.4 can't be used to circumvent the very clear wording of clause 20.1. When there's an event or circumstance giving rise to an entitlement, which may be an entitlement for actual delay or future delay, that is the trigger. And that is why Sir Richard Field's very eloquent judgment is to be preferred. When the contractor sees a delay event that he thinks is going to cause him delay, that triggers the 28 days. He doesn't wait 6 months later when the delay starts, which would make a nonsense of the proposal. And we said that there's nothing onerous or odd about any of this. This is how one would expect the contract to work, that when the delay event occurs, entitling the contractor to time, for example, an instruction to do some work in the future that will be on the critical path, that is what begins the 28 days. Lord, I'm slightly conscious of the no, we're doing okay for time, sorry. So that's the second of the 3 points I wanted to make on ground 4. The third point is in terms of the facts. So what we say is, well, even if Sir Richard Field was wrong, even if the contractor doesn't need to give notice until the delay actually starts, there is no challenge to the findings of fact as to when notices were given. And just to be clear, we readily accept and if we respectfully applaud the indication given by the court earlier today of the desirability of deciding the appeal properly without an overly pedantic regard to appeal grounds and so forth. Now, whilst that is a commendable approach, if I may say so, in relation to legal argument, very different considerations apply when we have in mind factual matters. So insofar as the court of first instance in a specialist court made findings of fact, if those findings of fact are not the subject of grounds of appeal and not the subject of permission to appeal, they have to be disregarded. There must be some limit to the scope of this appeal. A, because I'm not in a position to deal with them, and B, because it's in the public interest that parties have finality. It's one thing for discrete points of law that are of potential interest to the industry to go to the Court of Appeal. It's quite another for this esteemed court to have to spend time messing about with delay expert report, trying to puzzle out exactly when a delay. I mean, for my part, I've been involved in the case since the grounds of appeal was set. I had no idea what my learned friend was referring to, so I hesitate to speculate how easy it was for the court to follow my learned friend's very detailed submissions. Now, if we can go to what we said at the beginning of this process, my lord, this is my skeleton argument. If I can just find, sorry. So if we go to D53. So my skeleton argument, the respondent's skeleton argument, starts at D42. And we made this point. So this is my skeleton argument, my first skeleton argument dealing with ground 4. And we made the point that, so the contractor's arguing that the notice period for clause 20.1, first paragraph, doesn't start until the critical delay actually commences.
Sorry, I've lost you.
I'm so sorry, my lord. So I'm on page D53.
Yeah, paragraph.
My skeleton, so the top of D53 is paragraph 68, quotes the contractor's skeleton, where they put forward their argument of principle that the 28 days doesn't start until the delay starts. And then at paragraph 69, we say, well, that paragraph 70, we refer to the judge's first instance analysis of non-compliance at paragraph 55. And we say, well, given that, it's impossible to see how ground 4, in other words, a later calculation of the 28 days, it is impossible to see how this ground assists any of the delay events, let alone how it would result in an extension of time of 306 days. So far as the employer is aware, there are no delay events that would benefit from this point. We then, at paragraph 72, went to some examples. I mean, there are loads of delay events. We looked at the first couple to illustrate the point. Delay event, now reading at paragraph 72 on page D53, by way of example, delay event 1, the judge found that the contractor notified this event for the first time on 3rd of November 2020, a finding that is not challenged. So this is one of the delay events that, as I understand it, is subject to this appeal. So the judge has made a finding as to when the delay event was notified. That finding, which is obviously a factual finding, is not the subject of any kind of challenge. The contractor's involvement in the project ended in November 2019, when the contractor walked off site, a year earlier. It is impossible to see how this delay event could now be brought into play, even if the 28-day period commenced at some later point in time. So just pausing there, I accept this is just an example, but we put in more examples in the second round of skeleton arguments. The point we were making is, unless you're going to have some sort of root and branch review of the facts of the case, at present, the contractor's appeal is limited to an argument about whether Obriskin applies and whether the 28-day period should start when the delay starts. But there is no appeal about when the notices were given. And looking at this delay event 1, the judge made a finding about when notice was given, but he also made a finding about when the contract came to an end. And it is impossible to see how this delay event could be rescued given those findings. Similarly to... Sorry, my lord. Sorry.
Can I just, I understand the general point you're making, but take delay event 1. The judge has found as a fact that the notice was given on 3rd November 2020. Yeah.
Yes, my lord.
That's perhaps a bad example, but that's after the contractor's involvement in the project came to an end.
A year later, yes, my lord.
Yeah, it's a year afterwards, isn't it?
Yes.
But I think if I'm right, the judge has found when delay notices were given throughout the various delay events. Has he made a finding either way about when a notice? Sorry, about when on the contractor's argument the notice should have been given. Sorry, it's bad expression.
Well, no, he hasn't, my lord. What I was doing at this point, I just wanted to, the reason for looking at my skeleton was I was just pointing out that we made this point a very long time ago, that there is no appeal on the factual matter. So I'm just very keen to ensure that I'm not at risk, that there's going to be some completely new factual analysis, because we flagged.
That's what I understand. I understand that. What I'm trying to do is find out for my own purposes on what areas the judge made findings, and you say they're not appealed. That's fine, but on what area? And he's made findings about when the notices were given.
Yes, my lord. So if we go to that, so in the judgment at page
bear with me. He's made findings about when notices were given. Has he made findings about when the clause 20.1 time limit for giving a notice would have been crystallized in each case?
Well, if we look at his findings, my lord, he has where for example he's made the point that, well, the contractor was off site a year earlier. He hasn't gone on to find.
That's an obvious case. I agree.
It's such an obvious case, but they're all a bit like that, my lord. If we just look at how he's approached it, but I think my lord is asking essentially two questions: is what findings did the judge make about when notices were given, and what, if any, alternative findings did he make on the contractor's submission? Now, the problem that we have is that the contractor's case at trial and in this appeal is not presented by reference to the ground for being successful. So the ground for is, well, it's when the delay starts that we can give the notice, but that analysis isn't anywhere. I'll just show you, my lord, what I mean. So if we turn up page B64 is the place to start. So we're in the judgment. Now, What we have, this is paragraph 52 of the learned judge's judgment, and this appears to be taken from paragraphs 202 and following of my learned friend's closing submission. So the learned judge has very carefully set out verbatim, it's copied out, what the contractor was contending for in its closing submission. And the reference, my lord, we don't need to turn it up because it looks like this. The reference is A164. And when we made the point in our written submission for this appeal that the contractor hasn't explained how ground 4 would help it, my learned friend's supplementary skeleton referred the court to that passage beginning at paragraph 202. And I will just show the court that. So that's A109. Sorry. I'm so sorry, my lord. That's a false reference. I'm gonna stay where I was rather than trying to find it. But the short point is that if we stay in B64 for now, my point is that the judge at paragraph 52 of his judgment on page B64 carefully set out what the contractor was contending for. And when we raised the point in the appeal that it wasn't clear how ground 4 could possibly help the contractor, they did not put forward the analysis that my learned friend sought to put forward this morning or earlier today. What they said was, well, we'll see our submissions at paragraph 202 and following of our closing submissions, which is the material now on the screen.
But
so this is what the... Sorry,
right. The stuff on the screen at the moment deals with 2 time points for each delay event.
Agreed.
But first, when the delay event finished, and secondly, when the notice was issued.
Agreed.
What is the relevance of when the delay event finished, as opposed to...
I have no idea, my lord. That is exact. I'm sorry, I'm speaking of you. I'm so sorry.
As opposed to when it started, or when it could reasonably have been anticipated.
My lord, that's precisely our point. What the contractor was putting forward bears no relation to the analysis that ground 4 urges. As we've seen, what the contractor seeks to argue by ground 4 is, no, it's not when the delay event occurs, it's when the delay starts. We say, okay, well, where does that get you? That doesn't seem to help you. And they refer to this material. And as my lord has just pointed out, and as I think we pointed out in our own supplementary skeleton, this is nothing to do with Mr. Justin Aikenhead's analysis. These are wholly irrelevant periods. So there are 2 points in summary. The first one is the court, quite apart from the court's finding on the correct interpretation of 20.1, the court has made findings on when the delay events occurred and when the notices were given. And in some instances, it doesn't matter because it's obviously going to be more than 28 days. In reply, the contractor says, no, look at what we were arguing for at trial. It's this material here. And as my lord has just pointed out, but this doesn't fit in at all with the Obriscan analysis. This is when the delay event finished, which is nothing. The competing constructions of clause 20.1 are: 1, when the delay event occurs, for example, when there's a delay in information or a change, or 2, on my learned friend's case, when the critical delay actually starts. And as my lord's pointed out, what on earth has paragraph 52, the material at paragraph 52, got to do with that? So this was the contractor's case at trial, and as we understood it until today, the contractor's case in this appeal. And then if we scroll down to the learned judge's findings, we turn to paragraph 55, which is on B65. So we're still in the judgment. And at B55, and I think we went through these in the supplementary skeleton, and at the risk of repetition, these are all essentially findings of fact that are not the subject of any appeal. So the learned judge found delay events 1 and 14 were manifestly notified too late. As the employer points out, these events were notified for the first time in the proceedings, and there's no appeal against that findings. It doesn't make any difference how ground 4 gets on. Delay event 6, I think was the one we just looked at, first raised in extension of time number 4, served on the 30th of January, after the contractor had been replaced by the new contractor on the 28th of November. So MESC, my learned friend's client, not been on site for over a month. So it's impossible to see how ground 4, even if successful, could possibly rescue delay event 6. Delay event 2, receipt of IFC or for construction drawings. This was events number 1 and 5 for the purposes of the contractor's extension of time claim number 1. Should have been aware. I accept Mr. Allen's analysis with available documents that show the 28-day period for this event began on 24th of August. It's not quite clear to me, my lord, how he reaches the conclusion about some of these dates. But again, none of this is challenged, my lord. If it were, and if permission had been, in the highly unlikely event that permission had been given to appeal these factual findings, then obviously we would be advancing factual arguments today. But we would strongly urge the court not to disturb any of this. And then delay event 5, the court found it's implicit in the requirement that the contractor give notice of the relevant event or circumstance within 28 days. That it must satisfy the engineer when making an extension of time that it gave the necessary 28-day notice. This contractor failed to do. The engineer stating in his determination it was not possible to decide if the event had been notified in time. And then we have delay events 7 to 13. I should just make clear, my lord, if it isn't obvious, that as one sees from paragraph 55, that the numbering of the delay events changes, as is no doubt typical, so that what they were when the extension of time claims were being made isn't necessarily the same in the court proceedings, and that makes it particularly difficult to follow what's going on. And then again, the learned judge points out the fact the extension of time was submitted 9 months after the commencement of the last of these events. It was not possible to decide if they had been duly notified. So again, the learned judge found that all of these were out of time.
Yeah, the last sentence. Last sentence of that paragraph.
Quite so, my lord. Quite so, my lord. Quite so. And so that's why we said, and I took the court to our skeleton at paragraph 70, where we made the point, well, we don't see how any of this helps. And I just for completeness, I just want to take the court through the development of this argument. So D74, so if we turn to D74, this is the contractor's supplementary skeleton argument, where they were responding to the points that we had made. And one of the main points we'd made for grounds 1 to 4 is we simply couldn't understand, either individually or taken as a group, how grounds 1 to 4 would make any difference to the financial outcome of the case. And we do, I'm afraid, object to some new explanation being put forward today orally for the first time as to what those consequences would be. But in my learned friend's supplementary skeleton, his first supplementary skeleton, he sought to explain at D74 what the effect of these grounds would be. And what became clear at that stage was my learned friend was seeking to argue that, well, if it succeeded with all of grounds 1 to 4, or 1, 2, and 4, then that would enable it to recover a full extension of time. In other words, there is no case in relation to individual grounds, so that was helpful. But more crucially, what my learned friend submitted at paragraph 5E, still on page D74, he says, as detailed within paragraphs 202 to 208 of the contractor's closing submissions, in respect of the majority of the delay events relied upon by the contractor, and for which the judge agreed with the contractor that Panther was responsible, notice was served before the expiry of 28 days from when the critical delay for each event started. So that was the totality of my learned friend's case, as detailed within paragraphs 202 to 208 of his closing submission. And his closing submission, the relevant passage is, I think, at A164. So now in my learned friend's closing submission from trial, it's a relatively lengthy document, but this is the passage he's just referred to in his supplementary skeleton from page A164. And here is the text that we then see helpfully reproduced in the judgment at paragraph 52. And this is the text that elicited my Lord's comment that, well, this doesn't correspond, we say it doesn't correspond at all with the approach taken by Mr. Justice Aikenhead, because in each case it refers to when a delay event finished. It does not refer to or explain when the critical delay started, which is the approach that Ground 4 urges. And that's why today my learned friend sought to make good this fundamental deficiency in his case by taking the court to individual notices and comments made by his expert, material that we have absolutely no cause to look at until today. Now, my learned friend suggested that, well, these were the documents in the bundle. Well, that is a horror story. If a party can expand their grounds of appeal to challenge very detailed factual findings after a 4-day evidence trial, if they can expand their grounds of appeal simply by including some documents in a bundle, which, for the avoidance of doubt, we didn't actually agree the bundle. We simply stopped objecting to the previous form, which was to include absolutely everything. But we didn't spend time analysing the materials that my learned friend has just referred to, because none of them featured at all, either in the grounds of appeal or the skeleton. So we say that Ground 4, even if we're wrong on points 1 and 2, that Mr. Justice Aikenhead's approach does support Ground 4, and even if it is to be preferred as a reading of clause 20.1, we say that the appeal as formulated does not make any attempt to explain, well, how would that make any difference? And we would object to any such explanation being given for the first time at this hearing, given that these are technical specialist matters decided by a specialist court. Well, Lord, that's all I propose to say on grounds 1 to 4. And I think I am overrunning. I am slightly confused by the time zones. I should have finished at 1. So if I can just have a few minutes dealing with grounds 5 and 6. So grounds 5 and 6 are concerned with the prevention principle. And my Lord Glennie made the point that it's perhaps not necessarily helpful to refer to it as a principle. My Lord, my Lords, if I can just say by way of introduction, the provincial principle is, as we understand the contractor's case, it's only relevant to the liquidated damages part of the case, so it wouldn't be relevant to the prolongation claim. And my Lord, we say the case is extremely straightforward. The beginning and the end point of this dispute is the express wording of the contract. The parties have expressly and explicitly agreed to a regime, and it's not an odd one or a curious one. It is one provided by a highly respected international drafting committee that is in use all over the world. And what we say is, well, if the court is satisfied as to what the parties have agreed in terms of their express terms, that is the end of the discussion. And nothing in Doug Jones's article or Tony Marshall's article or Gaymark comes anywhere near explaining why that should not be the case. What the parties have agreed is as follows. The contractor is to complete by a certain date. The contractor has an entitlement to make certain claims for extension of time and or loss and expense in the circumstances described in the contract. Those circumstances include explicitly, because they are specifically named, breach of contract and prevention. And I'll just take the court to that last point. We go back to C44. So we're back in the FIDIC unamended part of the FIDIC contract, C44. Extension of time includes E, any delay, impediment or prevention caused by or attributable to the employer. So act of prevention is something that the parties have specifically discussed and agreed, or to be taken to have done so, and as indicated in a standard form of contract. So they've agreed that in certain circumstances, if the employer prevents the contractor from performing its obligations, then there will be a claim, there will be an entitlement. That's what 8.4 is providing for. But they have also agreed a claims regime that will restrict, potentially very significantly, the contractor's entitlement to make such a claim. And that's clause 20. And if there is any doubt about it, this provision at 8.4 is subject to clause 20.1. And therefore, as I indicated earlier, what the parties must be taken to have agreed is that otherwise meritorious claims, potentially very significant ones, may fail for failure to comply with 20.1. That's what the parties have agreed. And it's not necessary to try and justify this in terms of commercial purpose or why do parties agree, conditions precedent, where's all this going, how does it help anyone? This is what they have agreed. And the wording is so explicit and so free of ambiguity. And as I mentioned in my introduction, FIDIC keeps tinkering with the clauses. We're back on page C75. So this is clause 20.1. The second paragraph, if the contractor fails to give notice of a claim within the period, the time for completion shall not be extended. So we've got an explicit reference to acts of prevention as being an entitlement subject to clause 20.1, and then 20.1 provides that if they don't comply, then the time for completion shall not be extended. Now, in a modern, sophisticated commercial court such as this, obviously, the terms of the contract should be enforced. They are so explicit, they are so beyond clear as to what they mean. So the contractor's case has to be one of two kinds. Either that the words presently on the screen at 20.1 do not mean what they say, that the contractor is nonetheless entitled to an extension of time or is not liable for liquidated damages despite the wording of clause 20.1, or that the explicit wording of the contract, and in particular the words, the time for completion shall not be extended, that those words should not be respected for some reason. And as I understand it, it's the second of those that my learned friend contends for, that notwithstanding this very, very clear wording, it should be given some different meaning. Now, I can't say very much more about the wording. In circumstances where FIDIC draftsman has referenced both acts of prevention and then said, if you don't put subject to clause 20.1, and then in clause 20.1 said, if you don't comply with this notice requirement, the time for completion shall not be extended. It's impossible to see how the wording could be improved to make it any clearer. And we say that,
sorry, didn't want to stop you in midstream, but it is very precise, this clause. If you fail to give notice within time, three consequences follow. 1, time for completion shall not be extended. 2, the contractor is not entitled to additional payment. 3, the employer shall be discharged from all liability in connection with the claim, but nothing else. And the reason I emphasize that is it prevents, obviously, the contractor from getting an extension. It prevents the contractor getting prolongation costs or whatever may follow with an extension. It doesn't say anywhere that the employer will be entitled to claim damages even when it's the employer's fault that the contract's extended. So even though the time for completion is not extended, you have, as it were, a clause that remains with the time of completion of, say, 31st December. Has taken a date. That's not extended. The work is still going on at that time. But surely, in answer to the employer's claim, the contractor can still say, "But it was your doing. It was your breach of contract. It was your whatever else."
But that's not how the contract is. But when it comes to paying delay damages, there isn't any analysis as to how it came about. The relevant provision is So this, if we turn to C45,
C45.
which is clause 8.7.
Hang on a sec. Yep, delay damages.
So if the contractor, so we're looking at C45, 8.7, halfway down the page. If the contractor fails to comply with clause 8.2, time for completion, the contractor shall, subject to 2.5, employer claims, pay delay damages to the employer for this default. These delay damages should be the sum stated in the appendix to tender. So the time for completion is as determined in 8.2, but 8.2 obviously has to be read in conjunction with 8.4, which is entitled extension of time for completion. So we say, I understand my Lord's point, but we say that this cannot be interpreted. There is no other relevance to extension of time. Extension of time is not the basis of loss and expense. Extension of time modifies the time for completion under 8.2. That's what it does, and it thereby modifies. I'm sorry, my Lord.
Sorry, I interrupted you. Doesn't the extension of time also have an impact upon a claim a contractor may have for prolongation costs? I had always thought that the contractor could, subject to proof, obviously, could say, well, look, I'm entitled to an extension of time for 3 months, 6 months, whatever, and I'm entitled to claim prolongation costs for that, for all the extra time spent on site and what have you.
No, my Lord, because for numerous reasons, it's not as, I'm afraid it's not as, it doesn't work like that, because the extension of time may be for events which are neutral events, which don't entitle the contractor to prolongation. Conversely, there may be prolongation costs where individual sections of the works have been prolonged, but the overall completion is not. So there's no basis for assuming that an extension of time and prolongation costs are linked. They're not, so far as I'm aware, they're not linked in the contract.
I see.
So in a JCT contract, a UK JCT contract, I think there is a reference to extension of time, but one has a list of relevant events which entitle the contractor to extension of time, and relevant matters which entitle the contractor to loss and expense, but they're not the same lists. But the short point, my Lord, is so far as we're aware, the only relevance of clause 8.4 is to determining the time for completion under 8.2, which has the effect of 8.7, which is the contractor's liability for delay damages. So we say, my Lord, it would be an unrealistic and unnecessary unnecessarily strained reading of clause 20.1 to suggest that although the time for completion is not extended, the contractor is nonetheless discharged from its obligation to pay liquidated delay damages. And if one thinks about it, my Lord, one would, if that were what the parties intended, one would end up with a situation where one had the time for completion for the purpose of clauses 8.2 and 8.4, and then some other time, not referenced anywhere in the contract, but some other time, which was the time that the contractor actually had for the purposes of a liquidated damages claim, where, for example, there was a mixture of contractor delays, employer delays, and neutral delays. And we say that as a matter of common sense, it's what the parties have agreed here is totally straightforward and conventional. There is a time for completion. The parties specifically anticipate the possibility, as frequently happens, that there will be acts of prevention or other impediments caused by the employer or the employer's persons, the people the employer is responsible for. And the parties have agreed, in order to preserve the right to claim liquidated damages, that there will therefore be adjustment to the time for completion. And if one were to say, well, notwithstanding all of that, the contractor is discharged, where the employer from its liability, that we say would again, to use a cliche, run a coach and horses through the entire carefully put together mechanism.
Yeah.
Similarly, we say that the doctrine of pacta sunt servanda applies, that the contract means what it says, and there's nothing more to it than that. It is nonetheless briefly necessary to consider the alternative, that notwithstanding the very clear wording that the parties have adopted, that the court should in effect impose its own notions of fairness, or by some application of the prevention principle or case law or whatever it is that the contractor contends for. Now, if I can just briefly address the concept of the prevention principle, my lord, it came up in the course of my learned friend submissions that my lord Glennie made an observation about the prevention principle, and the proposition was put to my learned friend that, as I think as a matter of general application, one cannot take advantage of one's own breach, and that was how it was put. That, so in other words, an employer can't cause delay and then seek to recover compensation for delay that it's caused. Now, it's our understanding, my lord, and I suggest it should not be controversial, that the prevention principle and the doctrine that one can't take advantage of one's own breach are nothing more than rules of construction, and they are no more than guidelines. They are rules of construction that, to put it in simple terms, as is very obvious from the very old cases my learned friend has cited, it would be an odd kind of contract where someone agreed to do something and agreed that they would be liable for doing it, even though the party employing them prevented them from doing it. And that's all Dodd and Churton and all these other cases say, is that when reading a contract, there is an extremely strong presumption that a party taking on contractual obligations and therefore liabilities is not agreeing to compensate their employer for problems that that employer causes. It doesn't need to be supported by case law. It's such a self-evident proposition of common sense. Why on earth would someone agree to do something that the other party was entitled to stop them doing, and yet the first party nonetheless be liable? Of course, they could agree to that with suitably clear wording. So that's the background of all of this. But we do have suitably clear wording. We have a very well-established, well-known form that explains what's to happen. The form anticipates that there may be acts of prevention, and they're typically going to be in the form of additional work causing delay, late information or late possession or other contractors in the way. That those are the usual sorts of acts of prevention that arise. And as discussed earlier, but the parties have agreed that none of that's surprising. In the Victorian cases, when one reads about them, it's as though it's come as a surprise to everyone that, for example, the contractor agrees to do some work within a period, but the employer doesn't give the contractor the site for a few weeks. And that's obviously the contractor hasn't agreed to take that risk. Well, that's all fine. But in the modern world, where the contractor, the employer is providing the design, where because of for technical reasons or design reasons or for whatever reasons there are, it is an inevitable feature. It's not a surprising feature. It is every project. There are acts of prevention by the employer. Every case, every project going on in the Middle East or in Europe or anywhere of any sophistication, there are impediments and acts of prevention on the part of the employer and the design team. In other words, information that comes slightly late, additional work and so on. It would be an utterly bizarre and unique project where there were no variations that had some potential time impact. It would be the exception if there was such a project. And in those circumstances, the parties' contract makes perfect sense. It's not some sort of extraordinary injustice or unfairness. It's simply the parties' attempt, as best they can, to resolve an absolutely inevitable and everyday problem, namely something the employer, or more likely the employer's professional team, have done, which causes the contractor some sort of headache. And they've dealt with that by saying, well, in principle, the contractor will be entitled to more time so as to accommodate this. But all contractor claims are also subject to clause 20.1, because whilst on the one hand, it's important to recognise the contractor's need to have an adjustment to extension of time or compensation for problems, equally the parties, and in particular the employer, are very keen to avoid stale claims that are not addressed at the time, and so on and so on. Now, if one thinks about it in those terms, all of these problems immediately go away. My learned friend's referring to the doctrine of prevention as being incredibly important and going back 400 years. Well, it is important, but as I said earlier, it's nothing more than a statement of the very obvious that a party wouldn't, unless they have explicitly agreed to, a party wouldn't ordinarily agree to take on a liability that the other party could prevent them from from performing. That would require very clear wording, but that's, as a matter of principle, we'll fine. But in this particular situation, that is to say, every project ever of the last 20 years, the parties have addressed all of that, and they've addressed it with a very straightforward and commonplace arrangement. My lord, my learned friend referred to the Gaymark case. If I can just briefly bring that up. So it's at D25 is the relevant passage. No, that's wrong. I'm so sorry. So Gaymark is at E647. Oh, sorry, I think I was citing the my learned friend's skeleton. So the Gaymark is at E647, and the relevant passage is at E684. If I can just quickly bring that up. So this is the judgment that my learned friend relies upon. And paragraph 69, the learned judge in Australia says, acceptance of Gaymark submissions, employer submissions, would result in an entirely unmeritorious award of liquidated damages for delays of its own making. And this in addition to the avoidance of concrete constructions delay costs because of that company's failure to comply with the notice provisions. And if one looks at that, it's immediately apparent how this problem comes about. There is nothing to this. The decision in Gaymark is nothing more than saying, well, it's very unfair if a meritorious claim is lost due to lack of notice. But the parties have decided what is fair, or rather, FIDIC have decided what would be fair, and these parties have accepted what FIDIC have proposed. And what, in doing so, they have sought to strike a balance between the need to grant the contractual relief if there are acts of prevention or delays caused on the employer's side, with, in addition, a claims regime. And of course, the inevitable consequence of that is that meritorious claims will be lost, or meritorious defences to claims, because obviously an entitlement to extension of time is a defence to a liquidated damages claim. But that's literally all there is to it. That the learned judge in Gaymark is saying, well, as Sir Richard Field pointed out in oral submissions during the trial, the learned judge in Gaymark is just saying, well, this all seems unfair, but it's not for the court to impose its own view as to what would be fair or not. The limit of the so-called prevention principle is nothing more than, well, it would need to be clearly explained in a contract in express terms if a party were to be responsible for delays that the other party has caused. But we do have express terms. If the contractor doesn't comply with clause 20.1, delays that are otherwise on the employer's side become the contractor's risk. As I mentioned at the beginning, though, of course, it's nothing like as simple as that, because in reality, contracted delays are largely at the employer's risk because of the cap on damages at 10% of the contract sum. And secondly, it's not the employer that's doing any of this, it's an external professional team. And what the employer is concerned about is that it has a remedy against one party or another. So we say that the Gaymark appeal to fairness, or what would be meritorious or unmeritorious, is completely missing the point. It's simply a question of construing the contract and being satisfied as to whether it means what it appears to mean. My lord, my learned friend also relies upon various principles of DIFC law. Now, we would suggest that both under UAE law, insofar as that has any bearing on this exercise, and under DIFC law, the start and end point is, well, what have the parties in fact agreed? And as I understand it, my learned friend doesn't seek to...
Mr. Mark,
I'm so sorry.
Mark, sir, are you going to take long, or shall we continue tomorrow? I'm not concerned about myself. It's the registry. It's only 5:05, 5:30. I don't know. The courts in Dubai close at 4. It's already working very hard past 5:30. Shahila.
I'm so sorry, my lord. I have overrun.
Okay. Not for me. It's okay for you because you're still 11, 12. I don't know, Judge Ali, what you think. I'm okay. I mean, as I said, I don't want to drag the
I
So,
appreciate I have
if
everyone.
you're just going to take a few more minutes, fine. But if you're taking more than that, maybe we should, I don't know. What do you think?
It's fine. It's, as I understand it, it's 17:37. We said we'd finish at 17:30. I'm concerned we don't have too much to do tomorrow. If I were permitted a further 10 minutes and then to finish, if that were acceptable, I think would be better than resuming tomorrow morning.
Okay.
But I'm in the court's hands and of course the registrar's.
Yeah, but the case is tomorrow we're going to continue with something else, isn't it? It's continuing tomorrow. Yeah. Okay. Okay, we'll finish this in another 10 minutes and then we'll adjourn for tomorrow. Okay.
Thank you, my lord. So I just briefly want to address the suggestion that UA law or DIFC law has any bearing on this. It's my understanding that my learned friend accepts that the parties under DIFC law can contract out of the prevention principle. But as indicated, the so-called prevention principle is nothing more than a rule of construction, a presumption that a party wouldn't agree to an obligation that the other party could interfere with. But we've seen how the parties have dealt with that. And that, as we say, is the beginning and the end of it. And reference to other principles is unhelpful. If we can just briefly look at the provisions that my learned friend relies on. So my learned friend relies on Articles 57 and 58. So these are at E596. So this is the DIFC contract law. Article 56 provides at E596, express and implied obligations, the contractual obligations of the parties may be expressed or implied. We would suggest that as a matter of common sense, as is the case under English law, where there are express terms saying what is to happen, there is no scope for implied terms. And although Article 56 refers to implied terms, it doesn't mean to suggest that express terms would be overridden by implied terms. What one would expect is that implied terms would fill in gaps where the parties have not said something, but it is necessary that there is some provision for that thing. Article 57, the law provides implied obligations arise from the nature and purpose of the contract, practices established between the parties and usages, good faith and fair dealing and reasonableness. Again, there's nothing in that to suggest that one ignores the very clear wording of the contract in a case such as this. Implied obligations of good faith, that is materially different from the UAE Civil Code obligation to perform a contract in good faith. But what we say Article 57C is getting at is nothing more than that there may be circumstances where the contract is silent as to what is to happen, but nonetheless, it's obvious, it goes without saying, that the parties are to act in good faith. Now, an obvious example, which would apply under UAE law or under English law or here, is if, for example, a construction contract provided that the contractor was to be reimbursed their cost on presentation of invoices, that it would go without saying that the contractor would be limited to putting in a good faith claim, in other words, an honest claim for its costs, and that it wasn't to put in invoices that related to another project, for example. And under UAE law, I hesitate to suggest that is in practice what the obligation to perform a contract in good faith means, that one will be faithful to its terms and honest in dealing with one another. It does not mean that clear, explicit language is to be disregarded in preference to some more fair, or what the tribunal considers would be a more appropriate outcome. Indeed, that's the opposite of the position under DIFC law or UAE law. A further obvious example of good faith would be where a party has to make a decision that will affect the rights of both parties to the contract. For example, to make an assessment of a claim. The contract may not say that they're to act in good faith, but under English law, it would be implicit. And that is another example of how the duty to perform a contract in good faith under UAE law applies. And that's all that Article 57C is getting at here. It doesn't mean that one picks up gay mark and said, well, this is all very unfair because look, the employer's benefiting from delays that they've caused. All it's getting at is that, well, there may be areas where the parties have to rely upon one another to be honest and to trust one another, to perform their obligations in accordance with the true intention of the contract. And that's all this obligation's getting at. Now, Sir Richard Field's observation was, well, there are express terms dealing with all this. There's no scope for some implied term. And that also is in this case, obviously correct. But we say, even if it weren't, the good faith obligation is nothing to do with rewriting a contract. Now, in my learned friend's written submission, he says, well, it's understood that in the region, good faith is used as a sort of card, a trump card to overcome notice problems. Now, my lord, I'm sure my learned friend has immense experience of disputes. I know he has immense experience of disputes in the Middle East. That there are no authorities or commentaries put forward to justify that general assertion. My own experience, insofar as that's relevant, is yes, contractors repeatedly trot out good faith as some sort of reason for ignoring the terms of the contract, and that argument is a bad one. It is not what the obligation to perform a contract in good faith means. It is much closer to what I suggested, which is to be faithful to the terms of the contract and to the relationship with the other side. It's nothing to do with rewriting the contract, and instead the law in UAE, as under the DIFC, is the words of the contract should be kept, pacta sunt servanda. And so we say this is nothing to do with it. Now, in terms of my client's position, it's said against as well, you're benefiting from your failures, but in truth they're not. My client, there's been delay on the project. We don't know, but the overwhelming likelihood is that the so-called employer delays are nothing to do with the employer as such. What's happened is the parties have agreed a claims regime that, just as the rules of court provide that meritorious claims may in certain circumstances be lost, that's what the parties have agreed, and there is no absence of good faith. I do accept that there may be circumstances where under English law we would refer to estoppel or waiver, where, for example, an employer directs a contractor, don't put in notices under clause 20 because it's just provocative or it's annoying. One can well understand how a UAE civil code requirement to perform a contract in good faith, that some argument is akin to estoppel by convention or estoppel by representation under English law. One can well understand that sort of argument prospering, but that's not the facts of this case. And so we say my learned friend's attempt to pray in aid good faith as having any relevance to this is ill-fated. The culture of all of the civil code systems in the Middle East is that the words of the contract are to be honoured, and nothing in the good faith obligation overrides that. Similarly, the same or similar points can be made in relation to clause 58, cooperation between the parties. Each party is bound to cooperate with the other. Well, that's when such cooperation may reasonably be expected. Well, of course, that's right, that there are express terms in the contract requiring cooperation between the parties. There are also mechanisms explaining what's to happen when the employer prevents the contractor from performing, but there's also mechanisms dealing with when claims cannot be brought, and anything in this material prevents that. Well, my lord, that is my 10 minutes. I am extremely concerned that I've caused inconvenience to my lords and your excellency and the registrar. But I would propose to stop there. That there may be one or two of the points my learned friend raised in his additional material, but I am conscious I have the opportunity to put in a very short submission in a couple of weeks. So may I close at that point, unless there's anything I can assist the court with at this stage?
That's all. I don't have anything. So we continue tomorrow at 5 p.m. But before that, judges, Lord Glennie and Justice Ali, can we meet about 4:30 tomorrow, about half an hour before 5 p.m. tomorrow, or half an hour before 9 o'clock in London, and half an hour at 12:30 in Dubai, and 4:30 in Kuala Lumpur?
Sure, just like today.
Yeah, just like today.
Yep.
Sort of
Sure.
go through what we have heard today.
Yep.
Before we
Yep.
continue the hearing tomorrow. Is that all right, Angus?
Yes, that's fine by me.
Okay, good. Shala, you take note of that? Shala,
Yes, Your Honor. Yes.
can you send a judges discussion link tomorrow at 4:30?
Yes, I will be on leave, but I will let my colleagues know.
Yeah, please. Who's taking over your duties tomorrow?
Mr. Hamad Suleiman will be taking over.
Okay. Okay, Slamat. Okay, have a good holiday, Shala. And all the best. I will see you again tomorrow. Thank you very much, Mr. Mohan. Thank you very much,
Thank you,
Mr.
my
Bara.
lords. Thank you.
Thank you.
Okay.